Caribbean Court of Justice, Appellate Jurisdiction, on appeal from the Court of Appeal of Guyana, CCJ Appeal number 15 of 2017, between Quincy McEwan, Seon Clarke, Joseph Fraser, and Seyon Persaud versus the Attorney General of Guyana. Can we have the appearances for the court, please? Thank you.
Your Honours, Mr. Douglas Mendez leads Mr. Nigel Hughes, Ms. Mishka Puran, and myself, Clay Hackett, on behalf of the appellants in this matter.
Yes.
May it please Your Honours, my name is Kamal Ramkaran, and I appear with the Solicitor General of Guyana, Ms. Kim Hyde Thomas, Mr. Selwyn Peters, and Ms. Colleen Liverpool for the authorities of Guyana.
Yes, Mr. Mendez.
Much obliged to Your Honours. Your Honours, the areas of dispute have been narrowed somewhat as a consequence of the judgment of this court yesterday in the appeal of Neves and Severin as it relates to the applicability of the Savings Law Clause in Section 152 of the Constitution. And just so that you recall, Section 152 provides that except in proceedings commenced before the expiration of a period of 6 months, etc., nothing contained in or done under the authority of any written law shall be held to be inconsistent with contravention of any provisions of Articles 138 to 149 to the extent that the law in question, and it goes over, is a law that has had effective part of the law of Guyana, essentially similar wording to the Barbadian Section 26 of their constitution. What this court has held is that an existing law that is inconsistent with a provision that is not covered by 152, that is outside of 138 to 149, is not covered by 152. There is no savings in relation to that. And therefore, an existing law that is inconsistent with such a provision is liable to invalidity under the Supreme Law Clause. If I can refer you to your decision yesterday at paragraph 39, up top you'll see it says here that the view that better accords with protection of fundamental rights is the court is not prevented from holding that existing law may be inconsistent with the fundamental rights and freedoms in Section 11. There was no indication that Section 11 was omitted inadvertently or by mistake from the coverage of Section 26. And then over on the following page, you said in paragraph 49, just about here, that we therefore find that the mandatory nature of Section 2 of the Offence Against the Person Act places in violation of the right to the protection of the law. Under Section 1 of the Constitution, where such other law is inconsistent, the Constitution shall prevail, and the other law shall, to the extent of the inconsistency, be void. And therefore, you said it follows that the death penalty is void only to the extent that it is mandatory, leaving it valid to the extent that it is merely permissive, so that the court accepted, therefore, that if an existing law is inconsistent with a provision outside of that range, then it is void to the extent of the inconsistency. What you also held was that in relation to an existing law which is inconsistent with a provision covered by 152, then that law must be construed with such modifications as to bring it into conformity with the Constitution, so that the modification clause was to be applied. And you'll see that towards the bottom of paragraph 68, going over to 69, where there's a conflict between an existing law and the Constitution must prevail. The courts must apply the existing laws as mandated by the independence order with such modifications as may be necessary to bring them into conformity with the Constitution In our view, the court has the duty to construe such provisions with a view to harmonizing them where possible through interpretation on its inherent jurisdiction, etc. So that, as I say, narrows the area of dispute as so far as the coverage of the the savings law clause is concerned. Of course, we say that because the law in question is so vague as to be unconstitutional, it's not a law at all, and therefore it is not covered by the savings law clause at all, and must be invalidated altogether. Or alternatively, we say that it is inconsistent with Articles 1, Article 40, and Article 149D, all of which are outside of the range 138 to 149, and therefore they stand to be invalidated under the Supreme Law Clause to the extent of the inconsistency. And to the extent that the court finds that they are inconsistent with the freedom of expression, which is in 146 and therefore within the range, or 149, the discrimination provisions under 149, and they fall within the range, we say that it stands to be modified to bring it into conformity with the Constitution. So if your only finding is that the provision is inconsistent with 146 or 149, then we would ask you to modify it to bring it into conformity. So I will not be touching upon the question of the savings law clause any further unless there is anything further that Your Honours wish me to address as far as that is concerned.
Are you also not saying it's in violation of the unwritten principle of the rule of law?
Which we say is covered by...
Covered by one.
Which is covered by one, yes.
The democratic state.
That's correct.
In accordance with the rule of law.
But generally speaking, the learning is that if a law is so vague that it is not a law at all, it's unconstitutional without identifying any particular provision that is inconsistent with. It's simply not a law that will be recognized. But we say that the Article 1 prohibits a law of that type. And I'm referring, as a matter of fact, Your Honor, to your judgment in the Richardson case that you delivered 2 days ago, where I think that point is made. So I'll be bringing that to your attention shortly. So if I can deal with the violations, not necessarily in the order in which they appear in the written submissions, but if I may say we rely fully on the written submissions. What I'll be attempting to do is simply to highlight some of the points, but we rely in full on what we have said in the written submissions. But I would address, first of all, our contention that the provision violates freedom of expression under Section 146. If I can direct your attention, first of all, to the provision itself and remind you of its terms. You see, it starts here. It says that every person who does any of the following acts shall in each case be liable to a fine of not less than $7,000, not more than, yeah. And over the page, you will see in XLVII, being a man in any public way or public place for any improper purpose appears in female attire, or being a woman in any public way or public place for any improper purpose appears in male attire. And we have made a number of observations in relation to that provision. Of course, there are two elements to it. The man or the woman, as the case may be, must appear in public in attire of the opposite sex, of the sex opposite to his or her assigned sex, and they must be doing so for an improper purpose. Now, what is important to appreciate in relation to that provision is that it doesn't require actually that any crime be committed, other than, of course, this particular crime as defined. There is no victim of this crime. You can simply be standing in the road dressed as a woman if you're a man, or as a man if you're a woman, and you are entertaining an improper purpose for so dressing yourself, and you will be guilty of an offense. You cannot be doing anything in particular. You cannot be threatening anybody in particular. The offence is committed simply by the combination of the way you have presented yourself in public and what accompanies that comportment in your mind. Of course, to the extent that the police are able to discover what is in your mind, but the point is that the offence is committed without anybody being threatened whatsoever.
Or is it in the mind of the police officer?
Well, that's the point. At the end of the day, it's the police officer observing you and considering that your purpose for dressing yourself in that way is one that he or she considers to be improper, and therefore arrests you.
Mr. Mendes, when the charge was leveled, was there any specification of the improper purpose?
The evidence that was given by the police officer was that he had reports.
No. Even before you got to the evidence.
Yes.
The actual charge.
Yes.
Which...
Well, we've looked at the record, and there is nothing that indicates exactly what the improper purpose was supposed to have been. The magistrate simply says that the appellants appeared before her on the charge, and they pleaded guilty. She never says what the facts were that were read out. We don't even know if any facts were read out for her to have an appreciation of what constituted the charge.
So in that circumstance, it is quite possible that the improper purpose that was conceived by the police officer, the arresting officer, might very well have been different from the improper purpose that was conceived by the magistrate.
It may have been. We simply don't know because neither the magistrate nor the police officer has given any evidence of what improper purpose they were concerned about.
And similarly, the accused would not know how to defend himself or herself.
Well, to the extent that that was not given, no. And in this instance, the appellants were not represented. As a matter of fact, I think one of the deponents, was it the permanent secretary, had simply said that they were charged with appearing in public dressed as women. And that's it. He didn't say that the improper purpose was X, Y, or Z. So we really...
Do you know whether any female has ever been charged with this offense?
Not that I am aware of. I don't know. As a matter of fact, you will have seen that we've referred to a study that was commissioned by the University Rights Action Project that indicated that the provision has been applied only in relation to persons assigned who assigned male at birth who are dressing like women. That's the only men dressing like women that it has been applied to. And this is something that, of course, that I would address later on, but I think it's important to appreciate that the way things are now, that it is not surprising that a provision like this would only be applied in relation to men dressing like women, because I think you could take judicial notice of the fact that the styles these days, and at least for quite a long time, it's very difficult to say exactly what is male dress as opposed to, as far as a woman is concerned. Women have been dressing in trousers and shirts for however long. Women have been wearing trousers and jackets and ties, maybe not the same ties that men use, but it's something that you would consider to be ties. We have judges in Trinidad and Tobago who dress in jacket and ties all the time, and pants. There are lawyers who come to court dressed that way, and you would, I imagine, consider that to be male dress. But, of course, when a woman dresses in pants and shirt, they may be cut in a particular way that you would not necessarily consider to be male, but nevertheless, it is the same dress as you would consider a man would comport himself in.
So Mendes, just on that though, you mentioned that dichotomy.
Yes.
But I just wondered, are there many others who were dressed, who have been arrested and charged in Guyana? Is that a general complaint that you have.
The-
And of course, there is no charge of, no offense created just by dressing in a different attire.
Yes.
There's none at all. It is the improper purpose according to the section.
That's correct.
Yes.
That makes a distinction. But the question that you asked, have there been other charges? I'm told by Mr. Hughes that there for women. Oh, sorry, not for women is the answer, but certainly for men dressing as women, there have been other charges.
It's a common charge in Guyana?
The study is there attached to the report. I'm not able to say it is common. And let's say that there are others who have been charged. To describe it as common, that may be going a bit too far. But there are other persons who have been charged under the section, but never woman dressed as a man. So essentially, it is a provision that is applied to men dressing like women. Now, we say, first of all, that violates freedom of expression. As a matter of fact, both aspects of the offense, the way you dress and the accompanying thought, we say violate freedom of expression. And we have referred you to a number of cases. If I can take you through them very quickly, there's the case of Tinker against the Des Moines Independent Community School District. This is a decision of the Court of Appeal, and you see just at the top there that they held that the wearing of an armband for purpose of expressing certain views is a type of symbolic act that is within free speech clause of the First Amendment. Then you have the case of City of Chicago against Wilson. I'm sorry, the page number is 1017 for the Tinker case. The City of Chicago against Wilson case, the page number is 1040. And you will see that the synopsis, the defendants were convicted of violating a Chicago ordinance prohibiting a person from wearing clothes of the opposite sex with intent to conceal his or her sex. And towards the top here you see, notice that state can regulate one's personal appearance unconfined by any constitutional strictures whatsoever, is fundamentally inconsistent with values of privacy, self-identity, autonomy, and personal integrity that the Constitution was designed to protect. Then there's the case of Macmillan and the Itawamba County School, page 1036. And you'll see towards the middle of the page that the decision of the United States Supreme Court in Tinker was relied on. And at the bottom of the page, you'll see that it was, right down. Here you go. It was said that in the case sub judice, Constance requested permission to wear a tuxedo and even pants and a nice shirt to her prom with the intent of communicating to school community her social and political views that women should not be constrained to wear clothing that has traditionally been deemed female attire. Constance was informed by the defendants that girls were required to wear dresses to the prom, and in addition, the notice of a special school board meeting to address the prospective litigation clearly establishes that the school board was acting in response to Constance's demand letter, which contained her request to bring a same-sex date and wear a tuxedo to the prom. And the record shows that Constance has been openly gay since 8th grade, and she intended to communicate a message by wearing a tuxedo and to express her identity or through attending prom with a same-sex date. The court finds the expression and communication of a viewpoint is a type of speech. And similarly, in the case of Camis against the state government of Nigeria, this is a decision of the Malaysian Court of Appeal, I believe it is. This was a case in which, at page 1047, towards the bottom, 1047. It concerned a provision that made it an offense for any Muslim male person to do anything of the following in a public place: to wear a woman's attire or to pose as a woman. That was the offense. And you will see at page 1065, to the bottom of the page, the court said that Article 10(1)(a) of the Federal Constitution guarantees freedom of expression, and on the following page, at the top, that a person's dress, attire, or articles of clothing are a form of expression which in our view is guaranteed by Article 10(1)(a). And then towards the middle of the page, you see the decision of Tinker is referred to. So we respectfully submit that a man wearing women's clothing and vice versa, that is protected by the Constitution as under Section 146, freedom of expression. We say as well that the entertaining of a thought or a purpose, even a criminal one, entertaining criminal thoughts by itself is also a form of expression that is protected by the Constitution. Now again, there's an abundance of authority in that regard. We rely on the case of John Doe against the city of Lafayette, which begins at page 1086. This was a case in which John Doe had previously been convicted of a number of offenses related to the molestation of children. And he, on a particular day, found himself in a park where a number of children were gathered playing sports and so on. And he was entertaining thoughts of molesting those children. He managed to restrain himself and he left the park. But he later confessed to, I think it is a psychologist that he was seeing, that he had in fact been entertaining those thoughts while he was in the park. Somehow that conversation that he had was communicated to the authorities, and a ban was issued, preventing him from attending any parks at all. So the point that he raised was that his right to freedom of expression was infringed because effectively what he was being punished for was the thoughts that he was entertaining, even though that he had not taken any action in relation to those thoughts. The Court of Appeal originally upheld his complaint, but then there was a review of it by a larger bench in en banc, and that larger panel reversed the decision. But nevertheless, what we rely on it for is for the court's reaffirmation of the position that penalizing somebody from simply what they are thinking is a violation of their freedom of expression.
If
So,
you're only thinking, then you don't express.
yes. If you?
Well, if you think
Yes.
and you don't express your thoughts, how can there be a violation of the freedom of expression?
No, the violation occurs in the criminalization of the thought, the criminalization of entertaining a criminal thought.
Yeah, that's fine, but as long as you don't express it, how can it be a violation of your freedom of expression?
Well, in this particular instance, well, of course it is usually, or it would be unusual for the police to find out that you're entertaining criminal thoughts, because they are your private thoughts, and unless you communicate them yourselves, they would not find out. In the John Doe case, it so happened in unusual circumstances that the authorities did find out that he was entertaining those thoughts, and as a consequence, a penalty was issued. So that the question did arise in those circumstances because, in fact, a penalty was issued for the thoughts that he was entertaining. That was his claim. The point is that the court reiterated and re-emphasized that it is unconstitutional simply to penalize thought, unaccompanied by conduct. And this is what we rely on. If you look at page 1091, in this paragraph here, can we focus a little bit more? It says, a government entity no doubt runs afoul of the First Amendment when it punishes an individual for pure thought. And further on down the page, just at the bottom line, closer to this case, the court has also indicated that the government cannot regulate mere thought unaccompanied by conduct. That's over on the following page. There it is here. The fantasies of a drug addict are his own and beyond the reach of government, but government regulation of drug sales is not prohibited by the court, by the Constitution. Supreme Court, however, has made it clear that only government regulations aimed at mere thought and not thought plus conduct trigger this principle. And then drop down just a few lines. Limiting First Amendment protection to pure thought is rooted in common sense. Thought and action are intimately entwined. Consequently, all regulation of conduct has some impact, albeit indirect, on thought. And over onto the other page, the other side of the page here, the court said, although we can accept in the abstract Mr. Doe's argument that a government may not punish pure thought, we cannot accept his further submission that in subjecting him to this ban, the city punished him for pure thought. The city has not banned him for having sexual fantasies about children. It did not ban him from the public parks because he admitted to having sexual fantasies about children in his home or even in a coffee shop. The inescapable reality is that Mr. Doe did not simply entertain those thoughts. He brought himself to the brink of committing child molestation. He had sexual urges directed towards children, and he took dangerous steps towards gratifying his urges by going to a place where he was likely to find children in a vulnerable position. The point being that we are making is they're emphasizing that he cannot be penalized consistent with the Constitution, even for having fantasies about molesting children, as long as he's not acting on those fantasies. And there's a dissent, but which also refers to the relevant principles. You will see at page 1097, 1097, to the bottom of the page on the left. Yes, you will see at the bottom the question is asked, does the First Amendment protect a citizen's right to think about committing a crime, even if he has committed that crime in the past? The scenario is quite unusual and so on, because as is pointed out, Your Honor, as it is a rare case when thoughts as distinct from deeds become publicly known. Most thinking, unless purposely revealed to others, remains one's own, but nevertheless the principle is there. You are constitutionally entitled to entertain criminal thoughts. And as
isn't that specifically encompassed in this specifically laid out freedom, in that right to expression of freedom to hold opinions? The holding of opinions would also embrace thoughts.
Yes.
So that, to my mind, it is specifically laid out in the Constitution that one has a freedom to entertain thoughts.
Yes. That's what we are saying, that it is there in the Constitution. Just if I could make one further reference on the following page 1098, the paragraph to the left here. Indeed, even when an individual's ideas concern immoral thoughts about child pornography, the court has steadfastly maintained the right to think freely. And over on this side of the page, the government cannot constitutionally premise legislation on the desirability of controlling a person's private thoughts. First Amendment freedoms are most in danger when the government seeks to control thought or to justify its laws for that impermissible end. So that at the end of the day, what we are respectfully submitting is that both aspects of this offense, the way the person dresses and the thought that accompanies that dress, both are protected by the Constitution. But they're made an offense when they're joined together. It's not an offense if a man dresses a woman and has improper thoughts, an improper purpose inside of his home. There's no offense that is committed. It's committed as soon as you step outside of your home. So it's constitutionally protected inside your home, but all of a sudden you step out of your door and you're in public, you're on a road or in a public place, and it becomes an offense. We respectfully submit that the offense on its face violates freedom of expression. The state has not offered any justification for that imposition on the violation of freedom of expression. If this court agrees with that submission, then the law violates a provision that is covered by Section 152. And if at the end of the day that is the only violation, then it stands to be modified in order to bring it into conformity with the Constitution. We say, of course, that it goes further than that. It is an unconstitutional, vague law, and therefore it is liable to be struck down altogether. In that regard, Your Honours,
Yes, because it's very difficult regularly to prove a mental, the mental state of somebody.
Yeah.
We have that in murder cases, and
Yes.
for example, not many people will say, yes, I wanted to kill that person.
That's right.
But from the way it was done, usually there's an inference that that was the mental state of
Yes.
the person. So could that not be, I'm now just looking at this point only, there are many more points. But
Yes.
couldn't it be that from the way a person behaves, dressed in certain attire, there could be deduced the purpose of doing that, and that could be, whatever it is,
Yes.
improper purpose.
Well, this is what I imagine in order to enforce the law, this is what the police will have to do, unless there is a confession, as it were. This is what my purpose was. It starts with the police making a deduction as to the purpose for which you address the way you addressed, and also a conclusion that that purpose is improper. Because at the end of the day, one will assume that anyone who dresses, however you dress, you're dressing for a purpose. Whether you're a male and you dress as a male, you're dressing for a particular purpose. You're going out to dinner. You're going to a fete. The question is, on what basis is the police or a police officer to determine whether that purpose, which he is deducing or inferring from your action, is an improper purpose? And when it comes before a judge, on what basis is a judge going to conclude that the inferred purpose is an improper purpose? What is the guidelines, what is the guidance given in the provision itself which would lead a police officer to arrest or lead a magistrate to convict? And that is the difficulty that we have. There is no guidance given anywhere in the legislation. And of course, this particular provision, although it is contained within a whole list of what are referred to as minor offenses, there is no one unifying public policy purpose in the entire Act which would assist you in discovering exactly what the phrase improper purpose means. Or I almost said immoral, because that is the word that the Honourable Chancellor used. He seemed to switch the word improper with immoral, which is even more problematic, I would respectfully submit. But it gives an indication of the difficulty. Exactly what are the guidelines, what are the boundaries that have been established by the legislation to permit a police officer to look at someone who he or she perceives to be a male dressed as a woman, on what basis is he going to conclude that you address that way for an improper purpose?
If the improper purpose is in fact a criminal purpose, and it is then consummated, it's carried out, so a crime has been committed, then I assume that the prosecution could relate to the crime that has been committed, so that the charge of dressing for an improper purpose is not entirely necessary and doesn't advance societal aims in any particular way. Is that a fair comment, you think?
It does. No, it precisely. It's certainly if what the police officer is concerned about is that you have dressed the way you have dressed for the purposes of committing a crime, then charge you with a crime. The goal of ensuring law and order is followed does not appear to be furthered by that additional charge. If there's already evidence that you have dressed the way you have dressed to commit a crime, then the criminal justice system is satisfied by charging you with that particular crime.
Either conspiracy, attempt, or the crime itself.
Or the crime itself. In this particular instance, the police officer said that he had reports of persons, males dressed as females, robbing persons and soliciting for prostitution. Those were the reports that he had. Mm-hmm. There was no charge laid along those lines. The only charges that were laid were loitering, which was eventually discontinued, it appears, and the charge of dressing like a woman. But again, we don't know what the improper purpose was. We have no idea from the police officer what he thought the improper purpose was that he was charging the appellants for.
So the interest of the state can be protected adequately without resort to this charge?
Absolutely.
Mr. Mendes, I look at the fact that this law dates back to 1894. And there is a thought that there has been an inordinate amount of coyness in discussing this law. Because the almost Freudian reference by the Chancellor to an immoral purpose really indicates that it is a sexual moray which is being targeted by this particular law.
Yes, it is an imposition of it's an attempt to impose the standards that the legislators at that point in time wished everyone to comply with.
Right.
So at that point you had, what they were basically saying is that men should dress like men and women should dress like women. And
because otherwise what is involved in so dressing
yes.
is in fact conspiring to act against or inviting or soliciting persons to act against the order of nature, as one particular charge, dating back then,
yes.
Expressed it.
Or as the expression is used, contra bonus moris,
yeah.
Which is an expression that was problematic in another of the cases that I'm referring to. It is basically an attempt to impose the standards of the time, of course, by the persons who had the powers to pass the law.
I suppose it was the time of Queen Victoria.
It may have been, but
it was indeed. She had another 5 or 6 years after this law was passed.
Precisely. But if I can take you very quickly, I know, Your Honours, that the authorities are very familiar to you.
But before you do that,
yes.
Just a question. It's not a criminal offence if a female dresses in certain female attire for an improper purpose.
No.
Only if it's a male.
That's correct. Yeah, the point is this. As in discussing with my colleagues, I was using this example. If you have, let's assume a man, he dresses properly as a man, puts on a jacket and tie, cuts his hair neatly, shaves, looks decent, and his purpose is to knock on your door, and because he's dressed so decently, you have confidence that this is a person who is not up to no good, so you let that person into your house or into your yard, as the case may be. But his purpose for dressing in that way is to gain access to your premises in order to rob you. So he dresses in a particular way for a criminal purpose, but he is not liable to prosecution under this section, because one of the elements of the offense is not present. A man dresses as a man. If a woman were to dress like a man with that very same purpose, then the woman is guilty of an offense under that provision, and vice versa, of course. A man dressing like a woman for that criminal purpose is guilty of an offense under the section. But if a woman does the same thing, dresses like a woman but in a presentable fashion in order to gain access to your house, there is no offense committed under the section. And I will develop that further when we are considering the question whether the section violates the equality before the law provisions and the anti-discrimination provisions. I'll discuss that later. But that is the impact of the provision. It's very difficult not to conclude that what the section really is concerned with is how you are dressing, and in particular, the fact that you are not dressing to stereotype. That's what it really is concerned with. The question of the improper purpose is the window dressing so that you don't say, well, I'm just going to pick you up because you're dressed in that particular way. But the difficulty with adding on to it the phrase for an improper purpose is that there is no definition. There's no guidance as to exactly what that means, and therefore it vests in the police arbitrary power of arrest. And that is what the jurisprudence concerning vagueness is concerned with.
It's the same sort of difficulty, in your view, attend to other provisions which might outlaw disguising for an improper purpose or impersonating someone?
Well,
have you looked at those, Mr. Mendes?
No, no, not in any detail, but of course each provision will have to be considered separately because there may be other elements of the offence that will assist you in determining exactly what the phrase for an improper purpose means. In other words, the context might assist you in determining the area of risk.
Yeah, I'm just thinking,
Yes.
for example, in Trinidad and Tobago, as children, we all dressed up as army people and played mass.
Well, yes.
But now, of course, that's a big thing, and you can't any longer wear
That's right.
fatigues.
Yes, well, again, that's a specific provision that would have been
So
made for security purposes. But
you haven't looked at it to say how it's worded so that, is there an element of improper purpose, is it? Or is once you're dressed in fatigues, that's it?
no, I haven't looked at that provision at all, but I don't know if it is, well, the answer is no, I have not looked at it, and I haven't looked at other provisions to speculate as to whether those provisions would be similarly vague. The cases, of course, consider a number of criminal provisions in which words of general import are used, and the court had to determine whether that is too vague. And as the authorities indicate, you're allowed to get the meaning of the word from the context of the legislation. You're allowed to determine the meaning of the word for the purpose for which the legislation has been enacted. We, of course, ultimately will be saying you cannot gather that purpose from this legislation at all. So there's no assistance that is to be obtained from the accompanying provisions in order to determine what an improper purpose is.
Do you know if there are, in the region, in this part of the world, if there are similar criminal offenses in other countries?
Well, there are vagrancy laws all over the region.
Yes.
Whether there is a similar one to this, I'm
know
seeing
that
heads shaking that this is unique as far as the Caribbean is concerned.
But I do know that, for example, the neighboring country of Suriname doesn't have anything like this.
Yes.
But they still seem to exist.
Sorry.
The country still.
Yes, right. I noted that, Your Honors, and they produce judges every now and then as well. So it seems to be thriving. Your Honors, the case of the Observer publications and Matthew case, of course, we have cited for the proposition you see at page 199, paragraph 28.
What's, 5?
Yes, this is at page 550, where it is said, in the course of the advice, Lord Clyde referred to the principle of legal certainty that legal provisions which interfere with individual rights must be formulated with sufficient precision to enable a citizen to regulate his conduct. An implication such as that proposed by the Court of Appeal did not satisfy the test. It simply echoed the constitutional description of the kind of provision which might lawfully be made. And you will see in the Privy Council decision of Sabapathy and the State, from page 587 on the record, the principle is again stated, the principle of legality. Principle of legality requires that an offence against the criminal law must be defined with sufficient clarity to enable a person to judge whether his acts or omissions will fall within it and render him liable to prosecution on the ground that they are criminal. But the jurisprudence of the European Court of Human Rights shows that the requirement for clarity must be seen in the light of what is practicable, and that it is permissible to take into account the way in which statutory provision is being applied and interpreted in deciding whether or not the principle has been breached. And you'll see that just down below, the decision of the European Court of Human Rights in the Sunday Times against the UK is referred to, and this passage is quoted very often. In the court's opinion, the following are two of the requirements that flow from the expression prescribed by law. First, the law must be adequately accessible. The citizen must be able to have an indication that is adequate in the circumstances of the legal rules applicable to a given case. Secondly, a norm cannot be regarded as law unless it is formulated with sufficient precision to enable the citizen to regulate his conduct. He must be able, if need be, with appropriate advice, to foresee to a degree that is reasonable in the circumstances the consequences which a given action may entail. Those consequences need not be foreseeable with absolute certainty. Experience shows this to be unattainable. Against while certainty is highly desirable, it may bring in its train excessive rigidity, and the law must be able to keep pace with changing circumstances. Accordingly, many laws are inevitably couched in terms which, to a greater or lesser extent, are vague, and whose interpretation and application are questions of practice. So the point is that there is a balance to be struck. There will be circumstances in which it is impossible for the legislature to express what they are seeking to prescribe in other than in general terms. But at the end of the day, if the context of the legislation assists you in defining the area of the risk, then it will pass the vagueness test. In this particular case, they were concerned with what was the meaning of the word trafficking. And you will see the analysis on the following page, at page 588, where the court is saying, just below the reference to Annie against the Director of Public Prosecutions, that there is implied in Section 10.4 the requirement that in criminal matters any law must be formulated with sufficient precision to enable the citizen to regulate his conduct, so the principle of legality applies, and legislation which is hopelessly vague must be struck down as unconstitutional. But the precision with which is needed to avoid such a result will necessarily vary according to the subject matter. The fact that a law is expressed in broad terms does not mean it must be held to have failed to reach the required standard. In an ideal world, it ought to be possible to define a crime in terms which identify the precise dividing line between conduct which was and that which was not criminal. But some conduct which the law may quite properly wish to prescribe as criminal may best be described by reference to the nature of the activity rather than to the particular methods of committing it. And of course, those words were being used directly in relation to the challenge in that case, which was the word trafficking, which it was being said was unconstitutionally vague.
I get the impression that the idea is that if there is a pressing need to regulate something, societal need, then it is allowed to be
broader.
Be broader.
Yes.
But of course, if there is no such pressing need to tackle a certain issue, then it becomes more. Yes. The vagueness becomes more, makes it more vulnerable.
That's correct.
That's the impression I've got.
Yeah, this is in fact what has been emphasized in the Canadian cases in particular. The point, one of the factors that is to be taken into account is the social policy considerations in respect of which the legislation was passed. One of the cases, the case that I'm about to refer to, that is the Nova Scotia Pharmaceutical Society case, for example. That concerned a charge, if I can take you to it immediately. You see at page 595. This is a brief description of the charge. The appellants were charged with 2 counts of conspiracy to prevent or lessen competition unduly. And what was being alleged was that the word unduly was unconstitutionally vague. And at the end of the day, you see the analysis that the court engaged in was to look at the policy behind the legislation and to determine whether, having regard to the purposes of the legislation, am I able to, or is there sufficient guidance for determining exactly what unduly means? If I can take you to...
This was page, what you just mentioned, page.
That page is 595, yes. The case starts at 594 and goes on to 650.
Yeah.
There are some passages that I'd like to refer you to, if I may. Could I take you to page 614, first of all? At the bottom of the page, you see, right about here, the court says that the doctrine of vagueness is founded on the rule of law, particularly in principles of fair notice to citizens and limitation of enforcement over the page. Enforcement discretion. Factors to be considered in determining whether a law is too vague include the need for flexibility and the interpretive role of the courts, the impossibility of achieving absolute certainty, a standard of intelligibility being more appropriate, and the possibility that many varying judicial interpretations of a given disposition may exist and perhaps coexist. So those are all the factors that you take into account in determining whether the particular phrase is overbroad. If I may take you to page 621, the court is referring to the need for fair notice, and this is what is behind the vagueness doctrine. At the top of that page, the court says that fair notice to the citizen as a guide to conduct and a contributing element to a full answer and defense comprises two aspects. And the first aspect is that there is a more formal aspect of notice, that is acquaintance with the actual text of a statute. That is actually the promulgation of the statute so that you know that it exists. But down at the bottom of the page, the court points out, right down here, indeed, the idea of giving fair notice to citizens would be rather empty if the mere fact of bringing the text of the law to their attention was enough, especially when knowledge is presumed by law. There's also a substantive aspect to fair notice which could be described as a notice, an understanding that some conduct comes under the law. Jeffries calls it the core concept of notice. On the following page 623, the court says, here, fair notice may not have been given when enactments are in somewhat general terms in a way that does not readily permit citizens to be aware of their substance, when they do not relate to any element of the substratum of values held by society. It is no coincidence that these enactments are often found vague. For instance, the vagrancy ordinance invalidated by the United States Supreme Court in Papa Christou versus the city of Jacksonville, or the compulsory identity identification statute struck down in Colenda against Lawson. Hence, aside from the formal aspect, which is in our current system often presumed, fair notice to the citizen comprises a substantive aspect, that is, an understanding that certain conduct is the subject of legal restrictions. And as far as exactly how you are to determine whether you have fair notice, the court seeks to develop that at pages, beginning at page 626. At the top, the scope of precision. This leads me to synthesize these remarks about vagueness. The substantive notice and limitation of enforcement discretion rationales point in the same direction. An unintelligible provision gives insufficient guidance for legal debate and is therefore unconstitutionally vague. Legal provisions, by stating certain propositions, outline certain permissible and impermissible areas, and they also provide some guidance to ascertain the boundaries of these areas. Down at the bottom of the page, legal rules only provide a framework, a guide as to how one may behave, but certainty is only reached in instant cases, where law is actualized by a competent authority. In the meanwhile, conduct is guided by approximation. The process of approximation sometimes results in quite a narrow set of options, sometimes in a broader one. And over the page, legal dispositions, therefore, delineate a risk zone and cannot hope to do more unless they are directed at individual instances. By setting out the boundaries of permissible and non-permissible conduct, these norms give rise to legal debate. They bear substance and they allow for a discussion as to their actualization. They therefore limit enforcement discretion by introducing boundaries, and they also sufficiently delineate an area of risk to allow for substantive notice to citizens. Indeed, no higher requirement as to certainty can be imposed on the law. Semantic arguments based on perception of language, etc., are unrealistic. At the bottom of the page, and I think that this is where the court is getting to the crux of the test that they are applying, a vague provision does not provide an adequate basis for legal debate, that is, for reaching a conclusion as to its meaning by reasoned analysis applying legal criteria. It does not sufficiently delineate the area of risk, and thus can provide neither fair notice to the citizen nor limitation of enforcement discretion. Such a provision is not intelligible to us. The words are obscured by the stamp. The previous decision of this court, and therefore it fails to give sufficient indications that could fuel a legal debate. Yeah, the terms of notice. It offers no grasp to the judiciary. There's an exacting standard going beyond semantics. The term legal debate is used here not to express a new standard or one departing from that previously outlined by this court. It is rather intended to reflect and encompass the same standard and criteria of fair notice and limitation of enforcement discretion viewed in the fuller context of analysis of the quality and limits of human knowledge and understanding in the operation of the law. So effectively, what we need to search for in order to determine whether a provision is too vague, such that it is unconstitutional, is whether the provision itself gives indications, gives some guidelines, some boundaries, which would permit a legal debate as to exactly what is prohibited, exactly what conduct falls within the section, what conduct falls outside of the section. If you look, lastly, I think.
It's one thing to have a legal debate so that lawyers can understand what the criteria are, but I always thought that the law in the first place is not for lawyers, but for normal people. I think if we have to look at whether it's too vague, isn't normal people with some common sense able to understand what you may do or may not do? Apart from, because I think our reasoning is always very much concentrated on courts and lawyers.
Yes.
Which is fine, but in the end, a citizen must be able to understand what he can do and not do.
And also the police officer who is going to enforce the law, because it is the police officer who in the first instance is going to determine whether the vague provision is infringed, and arrest and deprive you of your liberty immediately.
I'm willing to accept police officers as normal people.
You are willing to?
Yes.
And they are, but the point is that they may not necessarily be, well, they're not judges certainly, and they may not be lawyers, and therefore they may not, what we are discussing here, that is the parameters for legal debate, may not apply easily to them. But I think what it is getting at is that ultimately you can't impose too high a standard on the legislature as far as defining the offence is concerned. You have to allow some leeway for the use of general terms.
Yes.
The balancing act has to take place, and I think that this is what...
And the more pressing, the more necessary it is to regulate certain behavior,
yes,
the more leeway you can allow.
Precisely.
And the question is this so very pressing?
Precisely. I mean, this is not an offence, this is a victimless offence. There's no one threatened by the conduct described in Section 153.
With a maximum penalty?
And it's a very small penalty, so it just seems to be, maybe in the original intent, in the late 19th century, simply to control people, get them off the streets. The undesirables off the street.
Yeah, because a police officer, if he thinks it's for an improper purpose, whether he's right or not,
yeah,
he can arrest.
That's right.
Throw you into the jail for the weekend. And then after the weekend, you go to court.
Yes. And if it is, and if you,
And maybe you'll find a very learned magistrate saying that it's not for any proper purpose, or it is, but anyway, by the time you get to the legal reasoning, you'll have spent a few days in jail.
and you're unlikely, because it is a minor offense, because the penalty is a small amount of money, $7,500.
I think maximum is 10,000.
It's 35 US. You may say, well, it's not worth it to hire a lawyer. And as in this case, the appellants were unrepresented and they pleaded guilty.
It's not worth it either to even plead not guilty and have to come back to court.
And to have to
again
come
and
back
again.
on another day to contest it, just simply not worth your time. So again, it is, at the end of the day, it is a tool that is going to be used by police officers to control so-called undesirables, persons who they consider to be undesirables, persons who they consider to be engaging in improper conduct or acting for improper purposes. And that is what the vagueness doctrine is directed at, or that is the danger that the courts see when they ensure that provisions that are unconstitutionally vague.
I'm sorry. Is this a conviction that that is recorded in your record? This is a conviction, for example, that will prejudice your right to get a U.S. visa?
I believe so. It's on record. Well, it would, of course, depend on the U.S. authorities, but it is a conviction on your record. The answer is yes to that.
I'm trying to understand how this vagueness argument fits into the overall picture
Yes.
that you're painting, because could the law be specific in such a way that it is constitutional? Because I thought you said that each component of the law
Yes.
was unconstitutional for other reasons.
Yes. Well,
So that even somebody entertained the thought of committing a crime, for
Yes.
example, or committing an immoral act,
Yes.
that is still an expression that they're entitled to, or a thought that they're entitled to. So would the specificity attending the legislation and legislating clearly what is being outlawed help
Well,
in this case?
Well, if it stops short of actually prohibiting conduct that impacts upon somebody else's rights, then there may be a challenge on another ground. It is possible to conceive, and in fact we have attempted to do so when we have asked you to modify it, if that is the only choice, modification. Mm-hmm. We have asked you to modify it to say that we asked you to put in the words, if a man disguises himself as a woman, or a woman disguises herself as a man.
As distinct from dressing?
As distinct from simply dressing, the intention is to disguise your identity in the facilitation of the commission of a crime. So this is what we are suggesting might pass constitutional muster. So that first of all, there's an element involved in disguise as opposed to simply expressing your gender identity.
That's a very tricky word, though, Mr. That's a very tricky word, disguise, because it can be used by so many different people in so many ways.
Again, as I said, Your Honors, it may be that it may be possible to challenge provisions of this sort on other grounds. Yes. But to the extent that you are asking me, is it possible to conceive of an offence involving the way a person dresses, which would pass constitutional muster? I'm saying we have tried to find one which involves disguising yourself in order to facilitate the commission of a crime, which is not just simply a thought crime. We are saying that there's conduct involved here.
But that would be simply enough to say a person who disguises himself or herself in order to commit a crime. It would be. You make even a distinction between a male disguising as a female, because you could also disguise, a male could disguise
as a postman,
as a police officer or whatever.
Precisely.
So
it is a disguise.
If it's about disguise, then that would simply be it.
Will that already be a crime, Mr.
I think that my learned friend has pointed to one offense of blackening your face, is it? Disguising yourself by blackening your face. But the impersonation, I think it is, would be, there will be impersonations and so on. There will already be offenses of that nature. Mm-hmm. Of course, we resort to the question of modification only if that is the court's only choice. That is our long stop position.
But that's not your first choice, obviously.
That is not the first choice. We are saying because it is unconstitutionally vague, it has to be struck down altogether,
yes, taken
off of the statute books. We say if the only provision that you say is violated is one in between 138 to 146, then you have to contend with the savings law clause, and all you can do is modify. Of course, your powers of modification are great. And I suppose with our limited experience, we have tried to find a formula which would not be unconstitutional. Mm-hmm. But what the courts below have said is that the provision really is getting at the type of scenario which involves a disguise. A man dresses as a woman to, I suppose, cause a taxi driver to lower his guard, and then he robs the taxi driver.
But when he robs the taxi driver, why is he or she not prosecuted for robbing the taxi driver?
Oh, precisely.
Why do we need this?
Precisely. To the extent that the police still feel the need to resort to that provision, and that is the example that my learned friends have given. That is what it means. But of course, if there is evidence that that is what you did, yes, Your Honor, I agree, then the person would more appropriately be charged with that offense. There's no need to rely on Section 153 at all.
Because I'm thinking of how it can be modified if one has to modify it. And in every scenario that I can think of, the underlying crime, the thing that really makes it a crime is by itself punishable, is by itself a crime. So then you come back to ask, well, then what purpose does it serve? Precisely.
And this is why, as I say, that is the fallback position. The first position is that it violates some fundamental provisions of the Constitution that are not covered by the Savings Law Clause.
Yes. You need to proceed a little faster, don't Mr.
I'm sorry. If I can do so, the next case that I wanted to refer you to is an example of a case in which the court took into account the social policy behind the legislation and therefore allowed the legislature more leeway. That is the case of Ontario against the Canadian Pacific Limited, and that was I'm trying to find the provision. Sorry, if you look at the first page here, sorry.
And what's the page number? The CCJ
page number is 675. And you see that right about here, the provision constitutes a broad and general prohibition of the pollution of the natural environment for any use that can be made of it. That was a phrase that was thought to be unconstitutional or constitutionally vague. And you'll see the court at page 677 making the point, right there, right here in this paragraph, that the purpose and subject matter of Section 13(1)A EPA, the societal values underlying it and its nature as a regulatory offence, all have some bearing on the analysis of Section 7 vagueness claim. Because environmental protection is an important societal value, legislators must have considerable room to maneuver in regulating pollution. Section 7 must not be employed to hinder flexible and ambitious legislative approaches to environmental protection. And again, taking you quickly, on the other side of the coin, you have the case of R against Morales. That is the Canadian Supreme Court case in which, this is 633, in which, I apologize, 833, in which the law in question authorized pretrial detention where it is necessary in the public interest. And it was being said that the phrase in the public interest was unconstitutionally vague. And the court, in fact, upheld that submission, if you look at page 854, to the top of the page, the court says, in my view, and going down, these authorities demonstrate that the term public interest has not been given a constant or settled meaning by the courts. The term provides no guidance for legal debate. The term authorizes a standardless sweep, as the court can order imprisonment whenever it sees fit. According to Nova Scotia Pharmaceutical Society, such unfettered discretion violates the doctrine of vagueness. What becomes more problematic is not so much general terms conferring broad discretion, but terms failing to give direction as to how to exercise the discretion, so that this exercise may be controlled. Once more, an impermissibly vague law will not provide a sufficient basis for legal debate. It will not give a sufficient indication as to how decisions must be reached, such as factors to be considered or determinative elements. As currently defined by the courts, the term public interest is incapable of framing the legal debate in any meaningful manner or structuring discretion in any way. And if I can take you very quickly through some examples of laws that have been held to be unconstitutionally vague. There's the Supreme Court of the United States decision in City of Chicago against Morales, starting from page 752. And towards that middle of the page, you'll see the clause that they were concerned with. The Illinois Supreme Court interprets the ordinance loitering definition to remain in any one place with no apparent purpose as giving officers absolute discretion to determine what activities constitute loitering. So the phrase that they were concerned with is being in a public place with no apparent purpose. And you will see at page 56, sorry, this will be 767, just beginning at the bottom here, it is difficult to imagine how, and then over to the next page, any citizen of the city of Chicago standing in a public place with a group of people would know if he or she had an apparent purpose. If she was talking to another person, would she have an apparent purpose? If she were frequently checking her watch and looking expectantly down the street, would she have an apparent purpose? Since the city cannot conceivably have meant to criminalize each instance a citizen stands in public with a gang member, the vagueness that dooms the ordinance is not the product of uncertainty about the normal meaning of loitering, but rather about what loitering is covered by the ordinance and what is not. The Supreme Court emphasized the Lord's failure to distinguish between innocent conduct and conduct threatening harm. And then at page 777, Justice, in the opinion of Justice O'Connor, at the top, she says, in particular, it fails to provide police with any standard by which they can judge whether an individual has an apparent purpose. Indeed, because any purpose standing in the street has a general purpose, even if it is simply to stand, the ordinance permits police officers to choose which purposes are permissible. Under this construction, the police do not have to decide that an individual is threatening the public peace to issue a dispersal order. Of course, we respectfully submit that a man dressed as a woman dressed as a man will always have a purpose. Whether that purpose is an improper purpose is, of course, the question in this case, and there is no guidance that is given to anyone to determine what purposes are improper and what are not. There's this important passage in the decision of the Supreme Court of the United States in Papa Christou, which was referred to in the pharmaceutical case dealing with vagrancy laws, starting from page 573, and I ask you to look at page 576 towards the bottom of the page. Just beginning here and going over. Go a little bit. Up. No. Right. Where he says, persons wandering or strolling from place to place have been extolled by Walt Whitman and Vachel Lindsay. The qualification without any lawful purpose or object may be a trap for innocent acts. Persons neglecting all lawful business and habitually spending their time by frequenting places where alcohol and beverages are sold or served would literally embrace many members of golf clubs and city clubs. Walkers and strollers and wanderers may be going to or from a burglary. Loafers or loiterers may be casing a place for a hold-up, letting one's wife support him in an intra-family matter normally of no concern to the police. Yet it may, of course, be setting for numerous crimes. The difficulty is that these activities are historically part of the amenities of life as we know them. They are not mentioned in the Constitution or in the Bill of Rights. These unwritten amenities have been in part responsible for giving our people the feeling of independence and self-confidence, the feeling of creativity. These amenities have dignified the right of dissent and have honored the right to be nonconformists and the right to defy submissiveness. They have encouraged lives of high spirits rather than hushed, suffocating silence. But of course, the use of these general terms make it difficult to express yourself as you may otherwise wish. The decision of the United States Supreme Court of Appeals in D.C. and MS against St. Louis, this is at page, sorry, apparently this one is not uploaded. It's on our list, but apparently not uploaded. But this is a case in which the court said that the use of the phrase indecent or lewd acts was too vague, and therefore it was struck down.
Please give us the name again.
It's the D.C. versus the city of St. Louis. What number is it on our list? I think it's at tab 24 of our list of cases, but number 24. And we'll make sure that it is uploaded ultimately, Your Honor. The case of City of Cincinnati against Adams, page 748. The offence in this case was you'll see that at page 749. 749, next page. It says 749. You don't have it there? Sorry, page 748. Charged with violation of Cincinnati Ordinance prohibiting one to appear in dress or costume not customarily worn by his or her sex with intent to commit an indecent or immoral act. And you'll see the court at page 750 saying, down to the bottom of the page a little bit, yeah, that additionally, right here, additionally, the element of an intent to commit an indecent or immoral act, while so dressed, represents an unascertainable standard. Both terms lack the precise definition necessary to withstand strict construction of a criminal ordinance. Such a prohibition depends upon one's moral philosophy and can, for example, include a female Christian scientist wearing a tie and pantsuit who enters a physician's office seeking treatment. So again, they're saying that this phrase, indecent or moral purpose, is too vague. Similarly, in the case of courts, this is at 827. This is a case in which the offence, you have it at page 828. At 828, you'll see the offence stated here. That it's ordinance makes it a criminal offence for 3 or more persons to assemble on any of the sidewalks and there conduct themselves in a manner annoying to persons passing by. And the court was saying that that is too vague. How are you going to know whether what you're doing is going to be annoying to this person or that? Some people may be annoyed, some people may not be. That was unconstitutionally vague. And lastly in this series is the decision of the European Court of Human Rights in Hashman and another against the United Kingdom, page 651. And what the court was dealing with in that case is someone who had been bound over to be of good behavior. And the question was, what does good behavior mean? You will see that the court, that the argument of the state at page 658, the argument was here. Sorry, further down. The argument was the government submits that the concepts of breach of the peace and behavior, contra bonus mores, are sufficiently precise and certain to comply with the requirement under Article 10.2 that any limitation on freedom of expression be prescribed by law. And if you look on the following page, 659, the state had relied upon a decision that my learned friends rely upon in this case, that is the case of R.V. Ghosh, in which the court had defined the word dishonestly in the context of a breach of trust. And of course we say that in the context of a breach of trust, it's not hard to determine exactly what dishonestly means in the context. But you will see that you see the court saying at on the following page, that is page 660, at par 37, the court first recalls that in Steele against the UK, it noted that the expression to be of good behavior was particularly imprecise and offered little guidance to be bound over as to the type of conduct which would amount to a breach of order. These considerations apply equally in the present case where the applicants were not charged with any criminal offence and were found not to have breached the peace. The court next notes that the conduct contra bono mores is defined as behavior which is wrong rather than right in the judgment of the majority of contemporary fellow citizens. It cannot agree with the government that this definition has the same objective element as conduct likely to cause annoyance. And then down just a little below here, the court says, conduct which is wrong rather than right in the judgment of the majority of contemporary citizens, by contrast, is conduct which is not described at all, but merely expressed to be wrong in the opinion of a majority of citizens. And nor can the court agree that the government's other examples of behavior which is defined by reference to the standards expected of the majority of contemporary opinion are similar to conduct contra bonus mores, as in each case cited by the government. The examples given is but one element of a more comprehensive definition of a prescribed behavior. And of course, you will have noted that my learned friend's submission is that you have to interpret an improper purpose as a purpose that the majority, I don't know if you use right thinking, people would think to be improper, but he says certainly the Wensbury reasonable judge would think to be improper. He is attempting to put that standard under the provision. But we say, of course, that we simply cannot know what the particular judge, or the reasonable judge, or the reasonable police officer would think to be improper conduct or not, because there is no guidance given to either of them to determine exactly what an improper purpose was. So we simply do not have sufficient notice.
Would you say that there are certain cases where you could say, well, that is improper, but so that I imagine that there can be cases you could identify, but then of course you have a lot of other cases where you can have all kinds of discussions.
Well, I mean, there may be cases that where we might all agree in this room that that is an improper purpose. We might all agree. But
then there are a multitude of
there may be a
cases.
number of, there may be instances which you consider to be improper that I may not consider to be improper. And again, there will be a reasonable difference of opinion between us as to what is improper and what is not. Unless we are provided with some guideline by the legislation itself by which we can resolve the dispute as to what is improper or not, then the average person who is subject to to being arrested for violation of this provision will be left in the dark. They simply do not know whether the particular purpose that they are entertaining when they dress the way they dress is one that a police officer might think to be unlawful.
Because when I was reading, well, I thought there is some logical inconsistency here. Now, for example, you're saying, well, what is female attire?
Yes.
We can agree that there are all kinds of attire that could be male and female, but surely there are some forms of attire that are typically female, as it stands now. And in fact, what you're saying is that the appellants are people who are biologically male,
yes,
but feel female.
Yes.
And they want to express that.
Correct.
So if you feel female, you want to express that in female attire, that would seem to suggest that you know what female attire is.
It does.
So I'm not saying that it is clear overall,
well,
but there might be instances. If it is that you want to express that, and that's fair enough,
yes,
then that would mean that there is some form of female attire. But then you can get into the most ridiculous discussions. So you could say a mini skirt is I don't think that is seen as a male attire.
Yes.
But then how mini must the mini skirt be?
Well,
I mean, a Scotsman can have something which we would call a skirt, and they call a kilt.
And a Muslim man who is wearing full kirta will object to your saying that he's in female attire.
Yes. So I suppose there are instances where you could all agree, well, this would be something, but there are so many other cases where you can have a whole lot of discussion. And then the question is it worth it to get into all of this stuff. And then we get back to the social need.
What is the social need for it, and balance that against the arbitrary discretion that is given to police officers to determine for themselves what is and is not female or male dress, as the case may be, and then what is an improper purpose.
And then you have said what is what the question of notice.
And that is what is at the heart of the vagueness jurisprudence. People need to know what conduct is prohibited and what is not. They need to have some guidelines as to what it is. Even accepting that there will be circumstances where you will allow the legislature some leeway to use general terms to fulfill some higher social purpose. Nevertheless, again, what is the social purpose in this particular case? And what is the guideline? What are the guidelines that are given by the legislation? And there is none. There are none.
Is there anything in the Interpretation Act or any other criminal law act that you have seen, a definition which assists us?
None that has been brought to my attention. None that has been brought to my attention. I don't know if my learned friends will be able to assist you as far as that is concerned. If you are with us thus far, Your Honours, then we say that that violates the right to the protection of the law, which we say is guaranteed under Section 41 of the Constitution. If you look at Section 41, you'll see that it is unlike the Section 11 of the Barbados Constitution that you will have considered in the Nervez case, because it doesn't spell out the list. It doesn't have the list of rights that are protected, but it says every person in Guyana is entitled to the basic right to happy, creative, and productive life, free from hunger, ignorance, and want. That right includes the fundamental rights and freedoms of the individual, and then subsection 2 says the provisions of Title 1 of Part 2 shall have effect for the purpose of affording protection to the aforesaid fundamental rights and freedoms. And we respectfully infer, and we ask you to infer, that the fundamental rights and freedoms referred to in Section 41 will, of course, include the protection of the law that is then set out in some detail at Section 144.1 onwards. And we respectfully submit that the same analysis that had been applied to the protection of the law in Barbados would apply here as well. And in that regard, we respectfully rely on this court's decision in the Nervez case. This is now at 6236 of the record, where this court held at paragraph 43. They also found that due process of the law is a compendious expression in which the word law does not refer to any particular law, is not a synonym for common law and statute. Rather, it invokes the concept of law itself and universally accepted standards of justice observed by civilized nations. And then in the following paragraph, the right to protection of the law requires, therefore, not only law of a sufficient quality, affording adequate safeguards against rationality, unreasonableness, fundamental unfairness, or arbitrary exercise of power. It also requires the availability of effective remedies. And we, of course, respectfully submit that a vague law does not protect a citizen from the arbitrary exercise of power. And then over the page at paragraph 45, protection of the law is therefore one of the underlying core elements of the rule of law, which is inherent in the Constitution and affords every person, including convicted killers, adequate safeguards against irrational, unreasonableness, unfairness, and arbitrary exercise of power. And of course, what is at the heart of the vagueness principle is upholding the rule of law. We say, therefore, that this law would violate the right to the protection of the law under Section 40. We say also that it violates Article 1, and you will see it there. This is at page 4928. Guyanese and Your Honours are very familiar with this provision. And in the Richardson case that you decided a couple of days ago, starts at page 6171, we rely on the judgment of His Honour, Mr. Justice Witt, and you see starting at page paragraph 112, as from the report it appears that Three other justices agreed with Justice Witt, Justices Hayton, Rajnathli, and Barrow. There's no indication as to whether the President, Sir Dennis, and Mr. Justice Saunders agreed with these, but it appears on the record that there were 4 of the 7 judges who agreed with Justice Witt. At 112, he says, the crucial question in this case is what are we to understand by a democratic state in the context of Article 1? And, Your Honor, you say at the last sentence of that paragraph, for proper analysis, it is necessary to focus on objective international standards of what a democratic state entails. And then over the page at paragraph 114, you say at the bottom of that page, as the Inter-American Court of Human Rights stated, the power to regulate or restrict rights is not discretional, but is limited by international law, which requires compliance with certain obligations that, if they are not respected, make the restriction unlawful. And then paragraph 115, you say, according to the Inter-American Court, the conditions and requirements that must be fulfilled when regulating or restricting these rights are A, the restrictive measure must be lawful, meaning that the restriction must be clearly established by law. And of course, this brings into play the phrase prescribed by law, and a vague law is not prescribed by law at all, it is no law at all. And we respectfully rely on this, and of course the other submissions that we have put in writing for the proposition that a vague law is inconsistent with the declaration in Article 1 that Guyana is a sovereign democratic state. If we have made good on those submissions, then, Your Honours, the provision will have violated 2 provisions, right to protection of the law and Article 1, that are not covered by Section 152, and therefore it stands to be invalidated altogether. We go further to say that the provision violates Section 149(1), which is at page 4957, that says no law may make any provision that is discriminatory either of itself or in its effect. And then in sub 2, it says, in this article, expression discriminatory means affording different treatment to different persons attributable wholly or mainly to the person, to their or their parents, guardians, respective descriptions of race, place of origin, political opinion, color, creed, age, disability, marital status, sex, gender, language, etc., whereby persons of one such description are subject to disabilities or restrictions to which other persons of the same or another such description are not made subject. And then we rely on 149D, which says that the state shall not deny to any person equality before the law or equal protection and benefit of the law. That is at page 4960. Your Honours, we respectfully submit that the Section 149D right is broader than the Section 149(1) right, to the extent that it would cover grounds of discrimination that may not be listed in Section 149(1). And for that proposition, we rely on the decision of the Court of Appeal of Trinidad and Tobago in Smith against L.J. Williams, 1472. And at page 1473, you will see at subparagraph 3 that this was a ruling in order to establish that it had suffered a breach of its rights, the equality of treatment by a public authority contrary to Section 4D. It was not necessary for the company to show that the breach fell within the introductory words of Section 4, discrimination by reason of race, origin, color, religion, or sex. And in the judgment of Justice of Appeal Hassan Ali at page 1512, he says, just below letter D, then it was said that to show a contravention of Section 1D, the company had to show that the inequality complained of was by reason of race, color, origin, color, religion, or sex, and that a contravention could not be established unless the evidence showed the discrimination to have been one or more of those specified grounds. I find no warrant either in the words of the Constitution or elsewhere for this interpretation. And the other judges of appeal had agreed with that proposition. I'm saying that simply by way of, in order to say, one, that if there's a violation of Section 149(1), there is also a violation of Section 149D, because Section 149D is a broader provision, but it doesn't, if there is no violation of 149(1), it doesn't follow that there isn't a violation of 149D, because 149D is broader. Now, just a couple of points by way of introduction to this part of the case that I wish to make, and it is that Section 39(2) of the Constitution expressly says that in interpreting the fundamental rights provisions, a court shall pay due regard to international law, international conventions, covenants, and charters bearing on human rights. And we ask you to uphold the decision of Justice George in, or at least this dicta in Taiwan Thomas against the Attorney General of Guyana, where she said at page 1564, at the bottom of that page, it is clear that the incorporated international human rights provisions in Guyana are not merely persuasive, and that the judiciary has to be constantly cognizant of these provisions. This specific mandate gives the court jurisdiction and makes it an obligation of the court to incorporate international human rights law into domestic law of Guyana when interpreting the rights and provisions of the Constitution. It is a mandate and jurisdiction which must be taken seriously and actively applied. Article 39(2) does not limit the court's inquiry to the human rights treaties listed in 4th Schedule, nor to those in which Guyana is signatory. And coupled with Article 154A, the Constitution now provides a framework for the court to explore the wide spectrum of human rights learning, and the court can therefore consider not only treaty law, but also the views and recommendations of treaty bodies and so on. And, Your Honours, we've spent a lot of time in our written submissions referring you to a number of decisions of treaty bodies under the CEDAW Convention and the Human Rights Council and so on. And I'm very aware of the time, and therefore I'm limiting the references I'm going to be making. First of all, I'd like to refer you to the advisory opinion of the Inter-American Court of Human Rights, starting at 1710, and at paragraph 78 and 79 at page 1748, the court says, based on the above and taking into account the general obligation of respect and guarantee established under Article 1, etc. At the bottom, the Inter-American Court establishes that sexual orientation and gender identity, as well as gender expression, are categories protected by the Convention. Accordingly, the Convention prescribes any discriminatory law, action, or practice based on the sexual orientation, gender identity, or gender expression of the individual. Consequently, no provision, decision, or practice under domestic law, either by the state authorities or private individuals, can reduce or restrict in any way the rights of a person on the grounds of their sexual orientation, their gender identity, or their gender expression. Of course, we are saying in this instance that our clients, the appellants, dress the way they dress as a matter of an expression of how they see themselves, of how they see their gender. The Inter-American Court provided some guidance as to the definition of these phrases that they used at page 1725. Gender identity is described as referring to a person's deeply felt internal and individual experience of gender, which may or may not correspond with the sex assigned at birth, including the personal sense of the body, which may involve a freely chosen modification of bodily appearance or function through medical, surgical, or other means, and other expressions of gender, including dress, speech, and mannerisms. Gender identity is a broad concept that creates a space for self-identification and reflects a deeply felt and experienced sense of one's own gender. Thus, gender identity and expression also take many forms. Some people do not identify themselves as either male or female, or identify themselves as both. And then gender expression is understood to be the outward manifestation of a person's gender by physical aspects, which may include dress, hairstyle, and the use of cosmetics, or by mannerism, speech, personal behavior, social interaction, and names and personal references. And then transgender or trans is then defined as when the gender identity of the person doesn't correspond with the sex assigned at birth. The gender identity of a trans person is not determined by surgical interventions or medical treatment. And the word trans is an umbrella term used to describe people with a wide range of gender identities, and the common denominator is that their sense of their own gender is different to the sex that they were assigned at birth and the gender identity that has traditionally been assigned to them. The point that we're making is that certainly, relying on all of the other references we make in the written submissions, that if a law is passed that penalizes a person for the expression of their gender, that it is attacking the person's identity, their gender identity, or the way they express that gender, it is a law that is discriminatory on the basis of sex or gender under Section 146 149.1 as well as under 149D. The case law, Your Honors, has developed to the point where the courts are concerned with laws that penalize someone on the basis that they are not conforming to the stereotype, that you are dressing yourself, or you are assigned a male at birth, but you dress yourself, or your mannerisms are the mannerisms of someone who is assigned female at birth. So you're penalized because you're failing to conform to these stereotypes. If you're penalized for that alone, then the authorities are indicating that that by itself is a violation of the anti-discrimination provisions, your right to be treated equally before the law. This is developed at great length in the case of, by the Supreme Court of Canada in R against Cap, which you'll find beginning at 1377. And I'll ask you to look at the exposition of the court on the section 15 of the Canadian Charter beginning from 1395. Where you see the court is saying at paragraph 15 on that page, starting here, that substantive equality is contrasted with formal equality is grounded in the idea that the promotion of equality entails the promotion of a society in which all are secure in the knowledge that they are recognized at law as human beings, equally deserving of concern, respect, and consideration. Pointing out that the concept of equality does not necessarily mean identical treatment, and that the former like treatment model of discrimination may in fact produce inequality. McIntyre stated the approach the ideal of full equality before and under the law, and in human affairs an approach is all that can be expected. The main consideration must be the impact of the law on the individual or the group concerned. Recognizing that there will always be an infinite variety of personal characteristics, capacities, entitlements, and merits among those subject to a law, they must be accorded, as nearly as possible, an equality of benefit and protection, and no more of the restrictions, penalties, or burdens imposed upon one than the other. In other words, the admittedly unattainable ideal should be that a law expressed to bind all should not be because of irrelevant personal differences, have a more burdensome or less beneficial impact on one than the other. But he goes on, while acknowledging that equality is an inherently comparative concept, Justice McIntyre warned against a sterile, similarly situated test focused on treating likes alike. An insistence on substantive equality has remained central to the court's approach to equality claims. What the court is warning against, in other words, is too strict adherence to the customary analysis of seeking to find a comparator and then asking the question whether the comparator is being treated differently. The concern is more to determining whether a person is being subjected to unfavorable treatment simply because who the person is, because of the characteristics of the person, without the need to determine whether there's somebody else like or who has similar characteristics who is being treated in the same way. And you see the court goes on, section 15.1 and 2 working together to promote the vision of substantive equality that underlines section 15 as a whole. Section 15 is aimed at preventing discriminatory distinctions that impact adversely on members of groups identified by the grounds enumerated in section 15 and analogous grounds. This is one way of combating discrimination. And if you look at at paragraph 17, and this is where they begin to develop it, the template in Andrews was further developed in a series of cases culminating in law against Canada, established in essence a two-part test for showing discrimination. One, does the law create a distinction based on an enumerated or analogous ground? And two, does the distinction create a disadvantage by perpetuating prejudice or stereotyping? These were divided in law into 3 steps, but in our view the test is in substance the same. And you'll see that there are further statements made in the case. As you look at page 1400, paragraph 25, By way of summary, I believe the court is saying the central purpose of combating discrimination as discussed under both 15.1 and 15.2. The focus is on preventing governments from making distinctions based on the enumerated analogous grounds that have the effect of perpetuating group disadvantage and prejudice or impose disadvantage on the basis of stereotyping. And we respectfully submit that this is precisely what this law is doing. It's saying that it is making criminal a man or a woman acting in a contrary to the stereotype. You are a man wearing female attire, a woman wearing male attire for an improper purpose, whatever that may be. The attack is on the stereotype. It's saying that each of us must stay in our corner and behave in the way that the powers that be think that we should behave and dress. Now that, the concept of penalizing conduct that is not considered to be stereotypical, amounting to sex discrimination, now finds its way into a number of authorities, including a decision of the United States Supreme Court in Price Waterhouse against Hopkins, which I'm not referring you to, but it starts at, it's on the list. I'll have to give you the page number a little later on, but it's on our list. But it is referred to in the case of Smith against the city of Salem, Ohio, which begins at page 2184.
Mr. Mendes.
Yes.
How long would you need?
I have just 2 cases to refer you to, and I'm finished.
Okay, good. Of course, there is a prohibition against cruel and inhuman treatment, so we have to keep it short.
Yes, I am almost there. Just these 2 cases, and I'll be done. To be honest. This was a case in which an employee, you'll see from the background of the case, move up a little. The city fire department employee who was born male and subsequently was diagnosed with gender identity disorder, I don't think that would be in use again today, brought Title VII action against city and various city officials alleging sex discrimination. That essentially was it, and you'll see the nature of the case that he was pursuing at page 2188. Down to on the left-hand column, down to the bottom, it says to establish, starting here, to establish a prima facie case of employment discrimination pursuant to Title VII, Smith must show that he is a member of a protected class, he suffered an adverse employment action, he was qualified for the position in question, and 4, he was treated differently from similarly situated individuals outside of his protected class. His complaint asserts that he is a male with gender identity disorder, and Title VII, prohibition of discrimination because of sex, protects men as well as women. The complaint also alleges that Smith was qualified for the position in question. He had been a lieutenant in the fire department for several years without any negative incidents, and that he would not have been treated differently on account of his non-masculine behavior and GID had he been a woman instead of a man. He was expressing his gender identity through his mannerisms, but also in the way that he was dressing, and he was subject to a penalty as a result. You see the court referring to the decision of the Supreme Court in Price and Waterhouse at page 2189, beginning here, Your Honors. In Price Waterhouse, the plaintiff, a female senior manager in an accounting firm, was denied partnership in the firm in part because she was considered macho. She was advised that she could improve her chances for partnership if she were to take a course at charm school, walk more femininely, talk more femininely, dress more femininely, wear makeup, have her hair styled, and wear jewelry. 6 men of the court agreed that such comments bespoke gender discrimination, holding that Title VII barred not discrimination because Hopkins was a woman, but also sex stereotyping. That is discrimination because she failed to act like a woman. And they referred to Justice White saying, accepting the plurality sex stereotyping analysis and characterizing the failure to conform to gender stereotypes as a discriminatory criterion, concurring separately to clarify the separate issues of causation and so on. As Judge Posner has pointed out, the term gender is one borrowed from grammar to designate the sexes as between as viewed as social rather than biological classes. And the Supreme Court made clear that in the context of Title 12, discrimination because of sex includes gender discrimination. In the context of sex stereotyping, an employer who acts on the basis of a belief that a woman cannot be aggressive or that she must not be has acted on the basis of gender. And the court made a similar finding in relation to this case.
Sorry, what year was this case?
This was in 1995.
Okay.
Sorry, 2004.
Thanks.
2004 decision. And you will see that in the paragraph just below there, Smith contends that the same theory of sex stereotyping applies here. His complaint sets forth the conduct and mannerisms which he alleges did not conform with his employers' and co-workers' sex stereotypes of how a man should look and behave. Smith's complaint states that after being diagnosed with GID, he began to express a more feminine appearance and manner on a regular basis, including at work. And the court was satisfied that he had established a case on the pleadings. There are other paragraphs that of course, Your Honours will refer to, but if I can just refer you to this last one. At page 2192, after Price Waterhouse, an employee who discriminates against women because, for instance, they do not wear dresses or makeup is engaging in sex discrimination because the determination would not occur but for the victim's sex. It follows that employers who discriminate against men because they do wear dresses and makeup or otherwise act femininely are also engaging in sex discrimination because the discrimination would not occur but for the victim's sex. Now, Your Honours, respectfully, where we submit that the courts below went wrong is in the comparator that they chose. And respectfully, I submit that this is where my learned friends go wrong. They say that the provision says that a man who dresses like a woman with an improper purpose or a woman who dresses like a man with an improper purpose are both subject to a penalty, and therefore there's no discrimination. They say men and women are being treated equally. But the comparator there is between a man cross-dresser and a woman cross-dresser. That is the comparator that they are using. We respectfully submit that the proper comparison to be made is between a man who dresses like a woman and a woman who dresses like a woman. A woman, as the examples I gave earlier of a woman dressing herself nicely and with the intention of causing you to let her into your house, but her intention is to rob you, she is not guilty of an offence under, she may be guilty of robbing, but she's not guilty of an offence under Section 153. But a man who does the same thing is guilty of an offence. And similarly, in the case of a woman who dresses like a man, etc.
The comparison reinforces stereotypical.
The comparison that has been by comparing a man cross-dresser, a woman cross-dresser, is entrenching the stereotype. And we say that that was the wrong comparison to be made. The right comparison is, all you do is you change the sex. You ask yourself, would somebody of the opposite sex in the same circumstances be subject to the penalty? And the answer is no. A woman who dresses like a woman in female attire with an improper purpose is not subject to a penalty under this provision.
But I thought you were going further to suggest that even a woman who dresses as a man is not prosecuted under this law, as is a man who dresses as a woman, so that you're suggesting that there's even a further...
That was the second submission. The second submission is that the way this provision works in any event, consistent with what I had pointed out before, but not only in practice is it that men who dress like women are the ones who are the targets of this provision, but because of how our modes of dress have developed, it's unlikely that women are going to be prosecuted under this provision. The target really is men.
Yes.
Target is men dressing like women.
Yes. You have 5 minutes more, Mr. Mendes.
Thank you very much, Your Honours. I'm referring you to the case of, lastly, sorry, Price Waterhouse is number 64 on our list, and you'll find it at page 2183. The last case that I'm referring you to, Your Honors, is the case of Hively. It's now at 6285. And this was a case in which a lesbian woman was denied promotion. Her case was that she was denied promotion on the basis that she was a lesbian. That is to say that she had a partner who was a woman. And she was arguing that in order to establish sex discrimination, the appropriate comparator is not a homosexual man who is having a relationship with a man. In which you don't ask the question, would an employer treat a homosexual man in the same way? The question that you had to ask was whether the employer would treat a man who has a relationship with a woman in the same way that he treated a woman who has a relationship with a woman. And this is the point that the court makes at page 11 of the judgment. I don't have the number on the record at the moment, but it's at page 11 of the judgment. And
yes,
the court says,
Mr. Mendes, you don't need to read this one. Before you sit, I wanted to ask you about the redress that you're seeking.
yes, Your Honor.
In your submissions, you say you don't attack the conviction.
No.
You simply want that the law be struck down or modified.
Yes, well, first position is struck down. And it's only if the court finds that it's only a provision within the, covered by the savings law clause that we say that it has to be modified. But our primary position is that it be struck down. The case was not framed initially as an attack on the conviction. And we have made it clear in the submissions in the High Court, the Court of Appeal, and here, that that is not what the case is about. As a matter of fact, that was our answer to my learned friend's point that the case is res judicata, and therefore we cannot raise it at all. He doesn't complain about us having standing to challenge the Constitution of the Act. He's saying you should have raised the point before the magistrate. And the answer, consistent answer since then has been, well, we are not challenging the conviction, we are challenging the law itself.
So your clients are prepared, if they are successful, to live with a conviction that has been arrived at on the strength of a law that you say is vague?
Well, Your Honor, obviously I think that if it is open to them also to have relief at this stage, even though they haven't sought it before, to have their convictions quashed, obviously we will not object. But I'm just being consistent. The case that has been, I am pointing out to you that the case that has been presented from the word go is that we are not challenging the conviction.
Yes, okay.
Would it make a difference? Would it make a difference if the law was struck down as opposed to modified?
Yes, of course. In which case, if it is struck down, then they wouldn't have to be looking over their shoulder to determine. They don't have to examine the terms of the law to determine
No, I'm going back to the
way
issue of
they're addressing.
I'm going back to the issue of the convictions.
Yes.
If a law is struck down, so
Yes.
it was never ever a law,
Yes.
doesn't that then affect whether they were properly convicted?
Sorry. Mr. Hughes is advising me that the conviction will have to be vacated.
Yeah. Whereas if it's modified, there might be a different answer.
Yes, it may be a difference.
Oh.
Okay. You have 1 minute and 40 seconds.
Well, I did want, I know you told me not to read, but I think it's important that I read that paragraph very quickly to you, Your Honor. It will not take me more than 1 minute and 40 seconds. And it's at page 11 of the judgment, and he says, it is critical in applying the comparative method to be sure that only the variable of the plaintiff's sex is allowed to change. The fundamental question is not whether a lesbian is being treated better or worse than gay men, bisexuals, or transsexuals, because such a comparison shifts too many pieces at once. Framing the question that way swaps the criteria, the critical characteristics, here sex, for both the complainant and the comparator, and thus obscures the key point, whether the complainant's protected characteristic played a role in the adverse employment decision. The counterfactual we must use in a situation is in which Hively is a man, but everything else stays the same, in particular the sex or gender of the partner. So what the court is saying is that in order to determine this case as to whether Hively was discriminated against on the basis of her sex, you have to ask the question, would you have treated a man who has a relationship with a woman differently? And we say that that is the appropriate comparator under Section 153. You compare between a woman who dresses a woman who is obviously not penalized under the section. And therefore, the determining factor of the penalty under this section is the sex of the person. And that therefore violates 146(1), 149(1), as well as 149D. And of course, 149D is a separate section not covered by the Savings Law Clause, and it stands to be struck down. To be honest, I think that is less than 1 minute and 40 seconds. And thank you very much, Your Honors. And
yes, thank you.
Further.
Yes, thank you, Mr.
Thank you very much, Your Honor.
Mr. Ramkaran, how long do you think you will be?
Your Honor, 30 to 45 minutes at most.
Okay.
I wonder, Your Honor, whether you would consider a very short bathroom break.
No, we are going to take a break now. I was just trying to think how long that break should be. And
If we need to be long, because we need to fortify ourselves, that in the event that you will be long, you see?
I'm not sure. It depends on how many questions Your Honor has. You can anticipate in the minute.
Okay, we'll take just a 15-minute break.
It's
Yes, Mr. Ramkaran.
May it please Your Honors. Today we are here looking at Section 153 of the Summary Jurisdiction Offences Act in a vacuum. This case is not an appeal from the case in which the appellants were convicted. This is a fresh case challenging the constitutionality of that law. So what we have here are not the facts of the case in which the appellants were convicted. We have different facts here. If Your Honors agree with me that the principle set out in Hunter and Chief Constable should be applied, my friends have made no answer to this authority. If Your Honors agree that this principle should be applied, then as a result of the fact that that conviction of a court having competent jurisdiction to hear the matter, which has not been set aside, remains final. The appellants could easily have chosen to appeal that decision on the basis that they were not aware when they pleaded guilty that they were in fact not guilty, but they never did so. It remains there, it remains on the books, although it's a minor offense. Your Honors are asking whether it remains on the record. It's a minor summary conviction. I don't think it remains on a permanent record, like a traffic offense. So, since this case is not an appeal from those criminal proceedings, the facts that we have here are very, very limited. All that we have here in this case is a contention by the appellants that they are afraid that they are going to be charged at some time in the future with this offense, and on that basis, this law should be set aside. Your Honors are well aware that cases should go on the basis of evidence. There is a report by URAP which my friend referred to, which is in the submissions. But that report, Your Honors, first of all, URAP is behind this case, and I think that is well known to everybody. So to prepare a report on the very issues which the case concerned should be something which is put into evidence, which can be interrogated, so that we can see whether the findings of that report are substantiated, whether they are not. But it's not in evidence. We don't have it. All that we have in evidence in this court is the contention that the appellants are afraid that they're going to be charged with this offense at some uncertain time, and that as a result, the law has to be unconstitutional.
So in other words, you're saying that the law should be looked at just on its face. The analysis should be to look at the law and to determine whether it is or is not constitutional.
Yes, sir.
And not be conditioned by what has transpired with the case. Is that what you're saying?
That is what I'm saying, sir. The basis for that is that we don't know what the actual facts were. We have an affidavit of...
What facts?
The facts of the matter in the magistrate's court. We can't assume that the facts put forward by the appellants are the correct facts. This is not an appeal from that matter. So if you use these proceedings as a collateral challenge to the convictions, what we end up doing is taking the evidence, the affidavit evidence of the appellants in these proceedings, the affidavit evidence of Odell Percival, which contradicts what they say, and using that to arrive at what may be and what is likely to be a different set of facts from those which were placed in the magistrate's court, and which the appellants agreed, to which the appellants agreed when they pleaded guilty.
Okay, but isn't it open to the appellants in this case to say that given what happened to them, what transpired in a case in which they were involved, namely this case in the magistrate's court, they view this law as either targeting them unfairly or they view themselves as being peculiarly vulnerable to this law in ways in which other people aren't?
They can say so, Your Honors. They can say so in their affidavit. They have not done so, unless Your Honors take what they've said in their affidavit and conclude that that is what they're saying. There's nothing preventing them from saying so, but Your Honors still have to draw the conclusion that that is so. And there is very little evidence that that is actually so. 4 people were charged on one occasion with an offense. That is the evidence that we have. That does not lend, to my mind, the conclusion that the entire transgender community is being targeted by this law. 4 people on a single occasion, late in the night and early in the morning, were charged with an offense. So how then can we draw the conclusion that this law targets transgendered people? We also have newspaper clippings.
But Mr. Ramkaran, the reality is that all transgender persons are susceptible to this law.
Properly speaking, that should not be so, sir. If the law is applied properly, that should not be so. We do have, Your Honor, newspaper reports of other people who we do not know to be transgender wearing female attire and committing various, what could be termed criminal acts. And we don't know whether they are transgender or not. One assumes that they are not, that they're doing it for disguise. So we do know that there are certain situations. There's one situation in which these 4 appellants...
Yeah, but Mr. Ramkaran, I think the point I want to make is that all transgender persons are subject to it.
All transgender persons may be subject to it, Your Honor, but that is the same situation as a person who owns property being subject to property tax, a person who drives a fast car being subject to a speeding ticket. People who are in certain situations are subject to certain things. A transgender person would not be subject to a conviction. A transgender person would have at his or her, in his or her armory, the remedies of malicious prosecution and false imprisonment if the law were misused. So while transgender people are susceptible to being charged, They have to be charged
But
properly.
why should a particular grouping of persons be susceptible, be vulnerable to the bad consequences of a law as distinct from other persons?
If the law is applied properly, sir, no group of persons is susceptible.
But their argument, you see, Mr. Ramkaran, is that this law is bad for the reasons advanced by their counsel. And they are saying, we therefore have come to court to challenge this law. We therefore should be heard in challenging this law.
Yes, that is correct, sir.
So we are exposed to it. We're saying it's bad. The state is saying it's good. We say, let the court decide. But we, the persons who are challenging, and the group that the fifth applicant or claimant is seeking to represent, these people are saying, we want to be heard in challenge to this law.
Yes, sir. And what I'm saying in this regard is only that we have here a factual vacuum. We have only what the evidence is before the court. We don't have any further evidence.
With the greatest, you don't need any evidence.
Pardon me, sir?
You don't need any evidence. You need the law.
If you look at the law on its face, and you look at the evidence that is put forward, it is not a foregone conclusion that the transgender community is susceptible to the application of this law.
Well, I will not engage you further on.
Yes, sir.
But I have, for now, a view on that matter.
Certainly, sir.
Yeah.
But this submission relates only to that aspect of the appellant submissions that relate to the transgender community, because there's another aspect of their submissions that relate to the rule of law and the vagueness and uncertainty surrounding the law. I'm asking you a question.
Yes, sir. The submission relates to the evidence that they've put forward, setting out the circumstances of their convictions. What my contention is that the court cannot look at that evidence. And when the court does not look at that evidence, what remains is the contention only that they are afraid that because this law exists, they will be charged under the law. So that is all of the evidence that is before the court in my submission. So,
and that leads to which conclusion?
that leads to the conclusion, sir, that you cannot draw wide inferences on how the law affects the transgender community, how the law is applied. The only thing that you can draw is that they say that they're afraid. These four people say that this is how they feel they must dress, and they are afraid that they will be charged under the law. And Your Honours must then determine, on the basis of those facts, whether the law is unconstitutional and whether the law is improperly vague, in my submission.
But we still have to look at that.
Yes, sir.
Because I thought one of your submissions was that, well, this is res judicata, so the court has no business in looking at the constitutionality.
No, sir, that is not my submission, sir.
That's not your submission. Okay.
My submission is that it would be an abuse of the process of the court to raise the facts from those proceedings in these proceedings as if the convictions never happened. That is the submission, sir.
Okay.
Your Honors, the court has the power to set aside a law. But that power, as Your Honors appreciate, is limited to unconstitutionality of the law. The court cannot determine that a law is archaic, a law is silly, a law makes no sense to the court, a law serves no social purpose in determining that the law should be set aside. The court can only set a law aside if that law is unconstitutional. Whatever views the judges hearing the case and the lawyers presenting the case have on the law have no bearing on whether the law should be set aside or not. A law should only be set aside.
You really want to state it in those absolute terms, Mr. Ramkaran?
Well, Your Honor, views lead to
because, for
conclusions.
instance, as your learned friend submitted, if there's a law which is archaic and it serves no current social purpose, then for instance, interrogating the utility of this law for society whether the law should be preserved or whether, because it serves no social purpose, it should be subject to a more strict inquiry, surely that's a factor.
It could be subject to an inquiry in relation to its constitutionality based on the principles of constitutional law. But the court has no power to say this is a silly law. This law serves no social purpose and therefore it is unconstitutional. It
Correct.
must be unconstitutional because it is unconstitutional.
You will not hold it unconstitutional because it's silly and archaic.
Yes, sir.
But given that it may be silly and archaic, and given that there are other factors which point to the unconstitutionality, those factors can conduce towards a greater disposition to the unconstitutionality of it, let's say for vagueness.
The reason I raise this argument, sir, is to say that Parliament is the place to deal with silly and archaic laws, not the court.
And would that Parliament were to act expeditiously in all our countries?
Your Honor, I would just like to remind Your Honors of what was said in Zuniga, which Your Honor was not a part of the court at that time, but Your Honor had other involvement in the case.
Okay.
In Zuniga, at paragraph 44, the CCJ quoted Justice of Appeal Mendez, as he then was, who said, "It is the business of the legislature to identify conduct which penal sections are to attach and to determine the severity of such punishment." At paragraph 49 of the decision, Justice of Appeal Mendez again said, "It is not possible to eke out an implied principle that the judiciary may second-guess the elected representatives on the question of what purpose it is appropriate for legislation to serve." On the question of what purpose it is appropriate for legislation to serve. Such a power would put the judiciary in competition with the legislature for the determination of what policies ought to be pursued in the best interests of Belize. In this case, it would be in Guyana. This court, the CCJ, agreed and said, in the realm of policy, the National Assembly is not only the best equipped, but it also has a specific remit to assess and legislate what it considers suitable for Belizean society. In this regard, Your Honors, the National Assembly of Guyana has passed a law. Many years have passed since this law has come into force. Successive parliaments have chosen not to change this law. And I would submit that unless it is very clearly unconstitutional, the courts should leave it alone.
No, it doesn't have to be very clearly. It just has to be unconstitutional.
Well, Your Honors, there is the principle of
Presumption of
constitutionality. Thank
that
you, Your Honor.
principle does not make an unconstitutional law constitutional.
No, sir, but it must be shown that it is unconstitutional. It must be shown. It's not on the mere allegation of unconstitutionality that the court would want to strike a law down. The court has to be cognizant that Parliament is the place where laws are made and social change is effected. Social change comes from Parliament and should not come from the courts. So I merely raise this to Your Honours, for Your Honours' attention, to remind Your Honours.
Well, I think we very recently reaffirmed that.
Yes, sir.
Parliament.
Your Honours, my friend has referred to two recent cases of Richardson and the decision yesterday. I have not had a chance to read, much less to analyze those decisions. My friend had the good fortune of being in both cases, so he's more familiar with them than I am. Your Honours, in terms of vagueness, it is agreed by both parties that a law must be capable of giving rise to debate. Well, legal debate. And if it is not capable of giving rise to legal debate, then it is unconstitutionally vague. Your Honours, over the past more than 5 years, the parties have been engaged in precisely that. Legal debate on the meaning of the phrase improper purpose. So it is capable of legal debate. It has a meaning. Improper purpose has a meaning.
But everything is capable of legal debate. The issue is whether this improper purpose is so vague, it lends itself so to such subjective interpretation that it does not inform the person who is charged with that law of what is it that they must meet. How should they conduct their defense? If the improper purpose is to commit a crime, that is one thing. If the improper purpose is to gain entry into women's toilets so you could peep on them, that's another thing.
That might not be a crime, though, Your Honor.
Well, whatever, the point is that any law that seeks to penalize a person should convey to that person what is it exactly that they're being taxed with? What is it that they must defend so that they could say, no, I wasn't doing that. I was doing something else. So if you have just improper purpose and no one knows, let me ask you a question first. The charge that was, we're not relitigating the case, and I take your point on that, but just as a matter of interest, and I don't think it is wholly irrelevant to the constitutionality issue. This is a matter of interest. Were these appellants who had a case in which they pleaded guilty, were they ever told what was, when they were charged, did the charge specify what was the improper purpose that they were alleged to have committed?
Your Honor, I'm not in a position to answer that because I have never seen the record from the magistrate's court. I understand it's just a case jacket. And there are hundreds of cases in the magistrate's court every day. And these physical documents go astray. I came into this case only in 2013, which is some years after the offense, the appellants would have been convicted.
But you would concede that if there were never, no specific allegation was made about the improper purpose with which the policeman or police officers who charged them had in mind when he charged them and based on which he charged them, then that would have been a serious defect because it would have rendered them incapable of being able to defend themselves against that charge. You would agree to that, wouldn't you?
If that were the position, yes, sir, but we have no evidence upon which we can make that conclusion. I know that in the magistrate's court, every time someone is charged, a set of facts is read with the charge that on so-and-so day you were doing so-and-so, which constituted whatever the offense is. So I know that that happens in the magistrate's court.
And you say you have not seen that at all?
That would not be on the case. Jackie, please, your
The facts read would be on the, would be
what
in the file?
What happens in the magistrate's court is that when the people are called, the magistrate will read something to them. On the so-and-so day, they charge them, on the so-and-so day, at so-and-so time, you are alleged to have been doing so-and-so activity contrary to Section 153(1) XLVII. How do you plead? And the plea is entered. And
you see, the problem here is that an ingredient of this crime is just an improper purpose without any guidance, without any parameters that set out, well, what is improper?
if this were a case, perhaps this is so, Your Honors, because this case is being done in a vacuum. If this were a case where there were specific circumstances, and in Zuniga, Your Honors, the court only took action against the legislation because it was clear that the mandatory minimum fines were grossly disproportionate to persons in Belize. That was a case in which there had not been an actual charge. In this case, if there was an actual charge, and there was something the court could go on, it would be much easier to determine whether or not this is an improper purpose for attiring oneself.
Let me ask you the question another way. If someone is charged with doing something, in this case dressing as being a male, dressing as a female, for an improper purpose, full stop, is that a proper charge? Can that ever be a proper charge?
But it would not be in that way, sir. It has to be based on facts, that you were doing something.
No, the formulation of the charge. That's what my brother is asking.
Yes, sir, but the charge itself, the offense, says a certain thing. But
But I think this is what the president is asking. If the charge sheet says, for that you, John Brown, on such and such a day, in a public place to wit, Frost Street, were attired as a female, you being a male, for an improper purpose, without going on to say, to wit, solicitation of prostitution. If there were not the to wit, would it be a proper charge?
I am not sure whether it would be a proper charge, so it probably would not be a proper charge, but it has to be based on evidence. So if you tell a person,
you haven't gotten
you have to
to
disclose
evidences yet, Mr. Ramkaran.
Yes, sir.
Before you get to evidence, you have to have a charge.
Yes, sir.
So we're
Indeed.
dealing with the propriety of a charge. And the question is whether that could ever be a proper charge to level against a potential
In that
accused.
form, I would say no, sir. But if it says for an improper purpose, being that you were doing something, then that would be a
Precisely.
proper charge.
Good. Okay. So
it is based on
making
the
some
facts.
progress.
Each charge, of course, Your Honor, as Your Honor appreciates, is based on the particular fact situation. So, and every charge that is read, as far as I'm aware, goes along with that you were doing something at a certain time, contrary to section so and so.
Again, we don't want to reinterrogate the criminal case, but you see, these persons who were convicted, they are aggrieved because they were convicted in a particular case based on this law. So what happened in the criminal case is relevant to their discussion, the allegation that this law is unconstitutional.
Your Honor.
What is it? No.
Yes, sir.
What is it that was improper about, what was the improper purpose that rendered them to be in violation of the law?
Well, Mr. Odell Percival, the policeman who charged them, has sworn an affidavit and has set out facts in that affidavit, sir. I think one circumstance was soliciting prostitution, and another circumstance was robbing passersby. This is what was said in the affidavit.
And they weren't charged for robbery?
I don't know what they were charged with, sir.
Solicitation?
Since this is not an appeal from that case, we don't have the material before us, sir. We can't come to the apex court and interrogate what happened there, unless, of course, it is part of the record. I haven't brought this case, sir. The appellants have brought it. It is their duty to put the record in such a position that we are able to ascertain what happened. If you want to bring a case, if you want to challenge laws, you must make it clear to the court that this is what the factual situation is. And if you don't do that, sir, the court cannot draw conclusions in the absence of evidence. To do so, sir, would be to do an injustice.
Yeah, but see, if you are challenging a law, then surely you can say this is an instance of how this law operates as evidence of the law's unconstitutionality, and that is what I think that they're doing. They're saying, look, we are not just here to say that this law, as you have suggested, is unconstitutional in a vacuum. We have been the victims of its unconstitutionality because we have gone through a process where, precisely because the law is unconstitutional, we have paid a penalty. And therefore, we would like the court to use those proceedings as a mere example. I will agree with you that, well, that's just one case. But surely, even if it's just one case, it can't be wholly irrelevant. It would have been better if we had more cases so that a more empirical assessment could be made. But even if you just have one case, at least you can extract from that one case some instances, some evidence to suggest that the law is or is not unconstitutional.
In this case, sir, we have two sets of contentions, the contentions of the appellant and the contentions of Mr. Percival. So how does the court determine which one of those are true? There's never been any cross-examination. Mr. Percival could have been called for cross-examination. Mr. Hughes, who appears in this case, has the reputation of making policemen cry and faint in the witness box. Surely he would have gotten Mr. Percival to change his evidence if it were that the evidence were not true. But no cross-examination was ever done of Mr. Percival. So here we have two competing sets of facts. How can we determine what the facts are? We can't. This is why it is so difficult to determine what the true circumstances of the law are, because we have no proper case, no case in which someone was alleged to be doing something which is dressing in being cross-attired for an improper purpose. It's very difficult in my submission, sir, for you to arrive only on the basis of the law and on the basis of the appellant's allegations that they're afraid that they will be charged on a conclusion on this matter.
Okay, so your submission is that what transpired in the case that was brought against them should be set aside entirely. We should just look at this law and on the basis of this law, without any other surrounding circumstance, assess whether it is or is not constitutional. And if we did that, then as far as you're concerned, there is nothing to suggest that the law is unconstitutional. That's your submission.
Yes, sir, and I say so because of the difficulty of the facts of the case which is not on appeal. Because we don't know what happened here. We can't find out what happened there. So all we have is this allegation that I'm afraid that I have to wear this clothes, and I'm afraid that I will be charged. That is all that we have. So, as Your Honor has pointed out, this is what I'm saying. It is extremely difficult to interrogate the law without the appropriate facts. You could determine in a particular situation, well, this charge is definitely unconstitutional because it targets this person. On the basis of this evidence that we have before us, this person is clearly being targeted, and this is wrong application of law. This is a misuse of the law. But that doesn't make the law unconstitutional. This would be, sir, like saying, I have an ingrown toenail, and therefore I will cut my foot off. If it is that people are misusing a law, that is state action which can be challenged on the basis of the constitutionality of that action. It does not follow that the law should be deemed unconstitutional because improper state action is being taken in the name of the law.
But what if the law opens up itself to its abuse by the executive? Then there's something about, in that case, there's something about the law itself. Wouldn't you agree?
Certainly, sir, but in my submission, it would be very difficult to arrive at that conclusion on the basis of the facts that we have here. We simply do not have the facts which would lead us to that conclusion. We have a law, and we have 4 transgender people who say that they've been charged. We do not know what the circumstances of those charges are.
No, we're not reinterrogating. We agreed. We're not reintegrating.
We don't know what. So we have only a fear that they will be charged. This case, they were last charged in 2009. This is 2018. There has been no allegation by these appellants in these proceedings that they have been charged again. So they have been apprehensive for almost 10 years that they will be charged, but no evidence that they've ever been charged again. One assumes that if they're transgender, that they dress like this every day. So you have everyday dressing by men in female attire, but no charges. So what conclusions are we to draw, sir?
Maybe they were not so dressed for an improper purpose.
Certainly, sir, but because there is an improper purpose that you can be dressed for, and if you are so dressed, then you can be charged.
Yes, the difficulty is that they don't know when they are so dressed for an improper purpose.
One assumes, sir, if they're transgender, then they're compelled to dress in the manner of the gender with which they identify, that they're dressed like that every day, that they go about their business like that. They're here in court dressed in the same manner. So
yes, but I'm not sure understanding each other. What I'm saying is that persons who are cross-dressed are cross-dressed.
Yes, sir.
But how do they know that they are cross-dressed for an improper purpose?
You can only know that a person is cross-dressed for an improper person if that person is charged and evidence is produced.
So the person knows then that they are dressed in that way for an improper purpose after they have been charged.
No, sir. The person knows that they're not dressed for an improper purpose because they're dressed in that way because they are transgender persons. So they're not dressed for an improper purpose. And there's no law in Guyana which prevents anyone from dressing how they can dress.
But how do they know then what the improper purpose is so they can avoid being charged? I think that is what we've been asking you.
If you are dressed, Your Honor, in a certain manner, because you are transgender, that is clearly not an improper purpose. No reasonable person could conclude that you are dressed in that manner for an improper purpose because you are transgender. Now, if someone were to make the allegation against you that you were dressed in a certain manner for an improper purpose, they would have to prove it. They would have to prove it by evidence, which could satisfy a magistrate beyond reasonable doubt that you were so dressed
But
for that
should the
purpose.
person know what that would be so they can avoid dressing for that purpose?
That would be something that is not, well, Your Honor, my friend said contra bona mores is too vague. But if you objectively did nothing wrong, were not dressed in furtherance of something which were wrong, such as a crime, fraud, harassment, you could never be susceptible to a charge.
I'm glad that you say that. And therefore, the law should say that it should specify those improper purposes that
Your
you
Honor has given the
identified.
example. I'm sorry, Your Honor.
No, my point is that I think you've made the point that you're saying that if you dress for an improper purpose, for the purpose of committing a fraud or a crime of some sort, then you know that you are dressed for an improper purpose. And it is for you to avoid dressing in that way in order to commit crime. So the law is bad if it does not go on to specify those purposes. But when the law simply stops short of making that detail, of giving that detail, then isn't one compelled to say that the law is uncertain?
Your Honor, there are any number of improper purposes. Your Honor has just given an example. A man who dresses like a woman to go into female washrooms to ogle women, that might not be a crime. There's something wrong. Now, the law knows...
It would be an improper purpose, wouldn't it?
It would be an improper purpose, sir. The law knows what is right and what is wrong. The law applies every day.
It is not enough for the law to know. I need to know, lest I be charged.
The law must tell us.
Yeah.
The people what is an improper purpose, because, for example, is it against the law for many people to congregate in an area, in a public space?
Not as far as I'm aware.
But what about purpose? If you're there for a riot, or is it just you can have a law that is so vague that how do people know how to avoid being charged? I think that is what we're trying to grapple with.
Your Honor, it has been my submission all through this case that in order to determine the parameters of this offense, one needs facts. You need to have charges. There may never be any other charges under this offense. But if the law were to be developed, there would have to be charges so that the law could be developed. Your Honor, in my submissions, I have quoted Lord Diplock in DPP for Northern Ireland and Lynch. He said, "Our task is to fit what we can see as principle and authority to the facts before us, and it is no obstacle that these facts are new. The judges have always assumed responsibility for deciding questions of principle relating to criminal liability and guilt, and particularly for setting the standard by which the law expects normal men to act. The common law, through the judges, accepts and sets the standards of right-thinking men of normal firmness and humanity at a level which people can accept and respect." So the courts are the places where these standards are set. The magistrates, based on facts, determine what these offenses mean. Your Honor, if you look at this, the Queen against Nigel Goddard, upon which I have relied, Nigel Goddard was importuning for immoral purposes. And I may note here, Your Honors, where the Chancellor in the Court of Appeal referred to an immoral purpose, I'm sure that was a typographical error. He was referring to Nigel Goddard, in which the issue was an immoral purpose. I don't think we should look too hard to ascribe improper motives to the Chancellor, an improper purpose to the Chancellor using the word immoral purpose. In Nigel Goddard, Mr. Goddard was importuning. The Court of Appeal said what an immoral purpose is, what the finder of fact thinks it is, based on contemporary standards. Now, 20 years ago, sir, being dressed in female clothing, if you were a man, because you were transgendered, would raise a great deal of eyebrows. Contemporary standards have moved on since then. Contemporary standards continue to move on. So what is an improper purpose today might not be an improper purpose tomorrow. The phrase is ambulatory and it is wide. Your Honor has said that you've tried to look at this phrase to see how it could be modified. There is no way that you can modify it without taking it apart and making it mean something else. It is wide for a purpose. If you dress yourself so as to facilitate wrongdoing, now wrongdoing is objective. Every reasonable person knows what is right and what is wrong. Courts apply what is right, not morally right and morally wrong, sir. Courts apply what society believes to be right and wrong. Courts apply this every day. This person is done in tort. Tort is based on fault.
The civil, though.
Certainly, sir. But crime is also based on right and wrong.
Yes, but it's specified what is right and what is wrong.
So courts have to look at facts, as Lord Deplock said in DPP of Northern Ireland and Lynch. The courts have to look at the facts and make determinations. Now, this section has been in existence for well over 100 years. It has never developed. Maybe some errant policemen decided one day to harass people by charging them, and maybe it will never happen again. And if it happens again, there is certainly a great deal more knowledge about it. Your Honours have made the point.
Why do you say they're errant? Because they might have thought it was an improper purpose.
It may have been an improper purpose. It could have been that they were errant, but it may have been an improper.
But there are no guidelines to tell them if they're aberrant or not. That's the problem.
Pardon me, Your Honour?
There are no guidelines to say to the police officer that this is or is not an improper purpose. So they themselves, I think, are a bit in the dark, shall we say.
Well, what is objectively something that is a crime would be an improper purpose. I'm sure Your Honours would agree that if you dress to facilitate yourself, to facilitate the commission of a crime, I don't believe, sir, that it matters that there's another offence. People are charged with multiple offences. It is no answer to say that you can be charged, you should be charged with robbery, and that this law should be struck out. That is no answer. The law is there, Parliament has passed it.
But I think it's the other side now, Mr. Ramkarandi. It is when the improper purpose is not criminal or unlawful.
If the improper purpose is not criminal, sir, would hiding yourself in a female washroom, if you're a man dressed in female clothes for the purposes of ogling women or harassing them, right, if that is not a crime, sir, would it still not be wrong?
It's an improper purpose.
It is an improper purpose, but it might not be a crime, sir.
Right, agreed.
But it is an improper purpose.
So there are other things which are capable of falling into improper purpose, which are not crimes.
And it is my submission, sir, that magistrates and judges who are trained lawyers are capable of determining what those purposes should be.
With the greatest of respect, it varies according to the magistrate.
If it
magistrate who will say to persons having been convicted of this offence, now listen, you all need to get on the right path. You need to turn to Jesus Christ and comport yourselves according to the normal standards of society. That is a magistrate who has that outlook. Another magistrate may be much more secular. Another magistrate may be gay. So it varies according to the individual. It's entirely subjective. That is the problem with it.
The application of every principle, sir, in every court is subjective based on what the court...
With the greatest of respect, you apply, you, the judge, do not apply the law in any subjective way. You apply it by reference to the stated objective criteria of the law. But when you have a law, such as improper purpose, which has no objective criteria, then what are you supposed to do as a magistrate? You supply your own criteria.
If that criteria were not capable of being objective, sir, if it were subjective criteria, but we would know what it is, because there would be certain facts alleged, and the magistrate makes a certain finding. Now, everyone knows, or everyone should be able to say, what is or is not objectively an improper purpose. We know.
Mr. Rankaran, let me take this a bit further. Section 146 of the Summary Jurisdiction Offences Act contains this lovely provision which I found intriguing and mind-opening. In proving a purpose or intent under any of the provisions of the two last preceding sections, granted 153 does not fall there, so acknowledge, it shall not be necessary to show that the person charged was guilty of any particular act or acts tending to show his purpose or intent. And he may be convicted if, from the circumstances of the case, and, look at this, from his known character as proved to the court, it appears to the court that his purpose was unlawful.
If Your Honor wanted to strike that section down, you'd find no objection from me.
If I want to what?
If you wanted to strike that section down, sir, that is a vague section.
That's a bit.
Seems to be
But that's
vague and
exactly the
meaningless.
point, Mr. Rankaran. What stops a magistrate from, in relation to 153.47, from applying the same approach?
The Court of Appeal, sir. The Court of Appeal, because if a magistrate makes an error, either in the forming of a conclusion, the drawing of an inference, or in the application of legal principle, such an error is subject to an appeal. And until the issue, there are no cases on this section, but until there are facts put to magistrates, hopefully there will be none in for this law, if the law survives today. If facts are put to magistrates and appeals are taken, the law then develops, a jurisprudence develops in relation to the particular matter in question.
How practical is that? Who has the money and the time to go to the Court of Appeal?
Well, Your Honor, this case is here before the CCJ.
No, this is an exceptional case.
And the appellants
normally people will not have that money. I mean, when we talked about comparators, it came to mind that I read somewhere that both a millionaire and a poor man are entitled to rent a room in the Waldorf Astoria. Yes, they are both entitled to do that, but the poor man doesn't have the money. So to concentrate on what judges and courts of appeal can find, that is one thing. But we have to think about the man in the street. He has to have an idea of what is possible, what is prohibited and not. And that is a difficulty with this particular issue. And why are we getting into all this fantastic reasoning for a provision which you yourself are saying is hardly ever used in the last 100 years?
We have to get into it, sir, because I cannot say that the court should strike it down unless it is unconstitutional, shown to be unconstitutional. So we have to get into it. Your Honor, I'm sorry, I lost my train of thought there, sir.
Could I ask you something whilst you try to
I think I've forgotten that.
Yes. Do you have other examples of modern legislation with criminal offences, which are this open texture, this sort of broad? Because I was a little concerned about that, whether this act is fairly unique in laying out these kinds of offences. Are there others?
I've referred to the word dishonest in submissions, both in a civil case and in a criminal case. Dishonest is as meaningless as an improper purpose, unless the courts give it meaning.
Dishonest.
Yes, sir.
Mm-hmm. Fair.
Pardon me, sir?
Fair.
Fair, just. There are many words that the court has to, they're broad terms which take into consideration a number of circumstances which the court has to develop, as Lord Diplock says. It doesn't matter if the facts are new. The court is here to apply what standards should be. The court is here to set the standards of the reasonable man. So the court then sets those standards.
I wouldn't have thought dishonest is quite as vague as improper.
Your Honor, improper purpose, the phrase improper purpose has been used in a number of decisions without comment, including Zuniga. There was an improper purpose argument. Your Honor, if someone were to apply Zuniga, the improper purpose argument.
There was?
Yes, sir. I can
Good heavens,
put it up on the
Mr.
screen for you if
Seon.
you want. I can, just as a matter of interest, I can put it up on the screen.
Please do.
Without comment. Everybody knew what this meant.
Sorry, what's that?
Zuniga, what page you're on, Mr.?
Page 123 of the West Indian Report's decision.
And what paragraph is it?
This paragraph is the heading to paragraph 46, sir. Section 68 and the improper purpose point. So the court went through this improper purpose point. And there are many, many, many other decisions which I've set out at length in my submissions in the High Court on the use of the phrase improper purpose. Another way that improper purpose can be used, Your Honors, is...
Sorry.
Just take us back to Zuniga, if you
Yeah.
There you go.
Where is the improper purpose? I see the word.
No, the phrase, sir, I'm only saying the phrase. It's not, I'm not saying that it was defined or anything. I'm saying the phrase has been used many, many times. The phrase is a phrase well known to the law.
But you have me sputtering,
No,
Mr.
no, sir,
Ramkaran.
no, sir, I apologize. I never meant to say that the phrase was defined. The issue was discussed, the improper purpose point. So
No,
the issue,
That was a heading given to a discussion.
no, sir, I apologize. The issue was discussed, but there was no definition of what an improper purpose is in that case.
My recollection is that the appellants in that case made certain arguments, and the judgment characterized those arguments and gave them a heading as improper purpose, so that it wasn't that there was anything in a law that stated improper purpose, and you had to analyze that law.
They were saying that the section could have been used for an improper purpose. And it is the same, sir, if someone misapplied this law to target transgender people, simply to target them, not because they were doing anything wrong. That would be the improper purpose of the section, using the section for an improper purpose. The phrase improper purpose is a well-known phrase and capable of understanding. It's not vague. It depends on facts for you to determine whether or not someone has been cross-attired for an improper purpose. And it might not always be a purpose which is unlawful, but it will always be something which is wrong, which the law recognizes as objectively wrong, which no reasonable person could ever think that was right. And that is the standard. That is the standard.
Mr. Ramper, I could ask you to take your best case and let us have what you consider a proper grappling by the courts of that term and improper purpose, and how it was defined.
Your Honor,
Give us your best case.
There is no case in which I have found the phrase defined. The phrase has been used many times without comment, but I've never found the phrase in which improper purpose was defined. And that is so, Your Honor, because it is a broad phrase which is incapable of definition. Any definition of improper purpose would make it mean something else other than what it is. Improper purpose cannot be defined. It is a wide phrase, and purposely wide, because it takes into consideration what is unlawful and what is wrong.
That's precisely the problem.
Your Honors would be able to determine what an improper purpose is only on the basis of the facts before the court, which is what happened in Nigel Goddard. Nigel Goddard was charged with persistently importuning for an immoral purpose. And the court said, well, that depends on what the findings of fact think it is. And that is what it is. It has to be context-based. It must be context-based. You will never find the meaning of it, but that does not mean that it is unconstitutionally vague. It is not vague if applied to particular facts. If you have a fact, a set of facts, it is perfectly open to the court to find and to find properly that in this case, the attire was being worn for an improper purpose, or in this case, it was not being worn for an improper purpose. And it is my submission, sir, that not because it might be difficult and appeals might not be easy or appeals might not be taken, that the law is unconstitutional. The one does not lead to the other.
But you see, Mr. Ramkran, you're treading on dangerous ground in the sense that if you're saying, well, the magistrate or the police, well, first the police, and then the magistrate will define what is an improper purpose. And, well, you have a right to appeal, and so the appeal court can sort of quash your conviction if you are wrongly convicted. Then it means that transgender persons who are not of great means and who don't have much social influence, they are always at the risk of this law. And invariably, it will be more expedient for them when they are arrested to plead guilty, as these appellants did, because they wouldn't have the means to pay a lawyer, and the time and effort it takes to challenge the law or to appeal or whatever, they just plead guilty, as they did. And so if you have a law that opens up itself to those possibilities, then how can one defend the constitutionality of
Your
that
Honor,
law?
in my submission, the answer to that will be public education, both of the police and of the transgender community. The police must understand that they are not to use this law to harass people. The transgender community must understand that this law is not a law which affects transgender people who are not doing anything wrong. You're wearing your clothes because that is your gender identity. That is not an improper purpose.
No, but the law never says they're doing anything wrong, Mr. Ramkaran. That's not the basis of
An
it.
improper purpose, Your Honor, is by its very nature something wrong. It is an improper purpose.
They're doing something wrong? Or
You're
they
wearing it
just
for an improper,
purpose?
in furtherance of an improper purpose. In furtherance of an improper purpose means to be doing something wrong.
Sir
That's the
Ramkaran,
meaning.
help me here. What is the status of gay persons, homosexual acts in Guyana? I don't know.
It is unlawful, sir.
It is unlawful?
Yes, sir.
Okay.
Homosexuality is unlawful.
Buggery, sir. It carries a...
Buggery is unlawful.
What's the penalty now these days?
Pardon me?
What's the penalty for buggery?
Life imprisonment, sir. So,
Which I think is a great improvement from what it was before.
I don't know. Was it the death penalty, sir?
Correct.
Yes, sir.
But that change happened in 1861.
Yes, sir.
So after that you were spared and you could just go to prison for life. That's all.
And in Belize, there's no penalty, sir.
Well, we have had the benefit of great
And in
Guyanese,
Trinidad as well, sir.
great Guyanese jurists in Belize, you see.
Yes, sir. Your Honor, my friends say that this offense criminalizes thought. But that's not so. You can only be convicted of this offense. And at this stage, Your Honor, may I digress to say, if you're convicted of an offense, according to Lord Diplock and Maharaj, no fundamental right has been breached because you have an appeal on fact or on law on your conviction. And if you get to a court where the final court says, well, there was no error here, then who can say that it was wrong? It was right. So, Your Honor, this offense does not criminalize thought because you must have mens rea. Mens rea is implied.
But wasn't the case that, well, first of all, this particular magistrate, and she admits that, more or less, that afterwards she gave them a kind of a sermon that they should go to church. That really fits into the picture of a moral conception of the persons that were standing before her. And then 4 years after, I think Chief Justice Chang gave his decision saying it's absolutely fine for transgender people to wear clothes of the opposite sex, as long as they don't do that for an improper purpose. I think 4 years later there was this case with the magistrate who threw some transgenders out of his court and told them, come back as you were dressed as a man. So these kind of incidents seem to reflect certain moral attitude towards people like these. And maybe, I think that is what one of the arguments from the appellants is that kind of mentality is more or less supported by this particular provision. So even though you might be absolutely right in that in the esoteric level of high jurisprudence, there might be very narrow nuances. One wonders if that is really so felt on the street or even in a magistrate's court.
If you have a societal mindset, sir, no law and no judgment of any court will change that.
I agree with
that. That can only change over time.
I agree with that. The point is, of course, if you have a criminal offense that is a state-created thing, which threatens to punish you with something, that is always a different kind of situation, to penalize certain behavior on moral grounds. That used to happen in older times, but that's not, I think, what we generally think should happen.
Yes, that is so, sir. But if you get rid of this law, that is not to say that there are not other laws that if police want to harass people, they can't harass them. There's another law that I refer to, which carries an imprisonment of 3 years as opposed to a fine of $10,000. If you disguise yourself in the night, you can disguise yourself by wearing female attire. Mm-hmm. If you disguise yourself, the section is quite compendious, sir. That carries 3 years. Now, unless societal mindset were to change, which is happening in Guyana, there was a pride parade recently, as I put the newspaper clipping. There was a pride parade, and the newspaper article was welcoming. The newspaper article was a nice article. People were on the streets celebrating. So society is changing its mindset, it appears to me. And reform of these laws has to come, in my submission, not from the courts, but from the Parliament and from the society after societal agitation. Mr. Joel Simpson, who is sitting in court, the managing director of SASAD, has been at the forefront of making this change, agitating all of the time, and it is happening in Guyana, more so, I imagine, than many other Caribbean countries. So,
well, I agree with you that we should not have the arrogant idea that by changing laws you can change mentality. That requires much more. We only focus on a narrow point, whether this law is unconstitutional. And in coming to a certain conclusion, yes or no, clearly all these things that have been mentioned might play a role. But it comes down to the question, is this unconstitutional and should it go? Or is it not? Then it should stay. But even if we would say it is unconstitutional, Parliament is free to come up with other laws. I don't think they would do that, but they're always free to do so. So, and maybe come up with laws that are more efficient than what this seems to be.
In which people will be convicted, as opposed to in this law in which you say, if I am transgendered, I am not committing an improper purpose. It may well be that they come up with more efficient laws, as Your Honor says.
I don't think that will happen, but anyway, that's in the hands of Parliament.
Your Honors, in relation to the issue of the section criminalizing thought, in Sweet and Parsley, what Lord Diplock said, and I've relied on it in my submission, is that the state has to prove the absence of a belief. In relation to this case, the state has to prove the absence of a belief on the part of the cross-attired person, the existence of which would make the act innocent. So you have to show that this person did not believe that they were doing something which was innocent. You have to lead evidence to show that. It is my submission, sir, that unless proper evidence is led, no person who is cross-attired because they are transgendered would be convicted.
How about because they are gay?
No, sir.
That person will also not be convicted.
If you are cross-attired because you are expressing your
homosexuality
or your fundamental right to freedom of expression, you say, I want to dress like this. I have been doing nothing wrong. If you know I'm doing something wrong, then you have to prove it. If you know that I have been dressed in furtherance of an improper purpose, then you must prove it, and you must prove it beyond reasonable doubt, or else I can be convicted. Now, if no evidence exists, you can get damages for unconstitutional action of the state, the unconstitutional application of the law. Your Honours have been developing this principle of equality under the law, where Justice Witt and later Justice Saunders have said this is what it means. It means that you're entitled to certain things. So, on the improper application or the use of the law for an improper purpose, the person who is wrongfully charged has recourse. That person has recourse. So, it is not to cut off the foot because you have an ingrown toenail, but to deal with the ingrown toenail, which is the improper application of the law. How is that done? The court can say, well, these are circumstances. You cannot use it to harm people who are marginalized. Law exists to be applied on the basis of evidence, not on the basis of anything else.
Coming back to the element of vagueness, there is something like the breach of the peace. Is that a criminal offense in Guyana?
I believe it is.
In some jurisdictions it's civil, in others it might be criminal. A breach of the peace also is a very broad expression.
I believe it is a crime in Guyana, committing a breach of the peace.
Yes. But of course, that it might be even broader than this one. But then coming back to the societal necessity, you need something like a breach of the peace. There might be at least a prohibition of that. There might be all kinds of situations that fit in there, but every society has something like a provision like breach of the peace.
Yes, sir. I cannot say anything about it. I just know that it exists because I've heard the phrase, but I don't know anything about the contents of that law, sir.
But one wonders if that exists in Guyana. Does that not cover? Does that not cover?
That might be vaguer than
anything like this.
That might be more vague than this, sir, because this is specific. Whereas a breach of the peace can be anything that the policeman thinks it is. Your Honour, the appellants complain also, in addition to the phrase improper purpose, that appears in female attire or appears in male attire is impermissibly vague. Your Honour, Justice Witt has said what I would have said, that if you know what the attire is because you're compelled to dress in that attire, it can't be vague. You know what it is. And it couldn't be, sir, that attire is limited to specific items of clothing. It has to be that you are attired as a woman or you're attired as a man. You have made yourself, by reason of your clothing, to appear as a man or appear as a woman. These phrases can only be determined on the basis of evidence before the court at a particular time in my submission. But until such a time when we can no longer tell men and women apart on the basis of how they are attired, the words can't be vague. We can still tell men and women apart on the basis of how they're attired. Your Honours, the cases that my friends have relied on and that the state has relied on say the same things. The law must be adequately accessible in the sense that it gives a person adequate indication of the law relative to his situation so that, if need be with advice, he can regulate his conduct. This is Shum Kwok Sher against HKSA. And on the other hand, the degree of precision required varies according to the context of the law. So every court in Hong Kong, in the Privy Council, in Canada, they've all said that certainty is good, but absolute certainty can only deal with particular situations, a particular situation, particular instance. So certainty is good, but there must be an area of discretion. It must be capable of being understood. And in my submission, this phrase, improper purpose, is capable of being understood. It means something unlawful or something objectively wrong. And objectively wrong is capable of being ascertained as it is ascertained by judges every day. Your Honors, in relation to the unconstitutionality of the law, I rely on the principles set out by Lord Diplock in Maharaj that the judgment of a court cannot breach your fundamental rights because you have recourse to an appeal, and you have further recourse to an appeal. So, if you are convicted, it doesn't breach your fundamental rights. If you are charged, it doesn't breach your fundamental rights because a charge is an accusation. And as I said, Your Honors, if the law is being improperly applied, then there is recourse to that application, not to the law. In each instance of the improper application of the law, there is recourse to challenge that improper application of the law, rather than to look at the law. The law is innocuous and it exists there without any problem. People misapplying it do not mean that the law is unconstitutionally vague. So a charge is simply an allegation that you have done something which has to be proved beyond reasonable doubt. And of course, as I said, Your Honors, there are remedies for improper charges. In addition to constitutional action, there is malicious prosecution and false imprisonment for which you can get damages. If it is that the appellants were alleging that a group of people, a group of marginalized people, were being harassed by the police, then there must be evidence to show that. There is, in my submission in this case, no evidence to show that. Evidence is anecdotal only. And the court is aware of at least 3 other instances where men cross-attired themselves who were not said to be transgendered to do improper things as reported in newspapers. So how, in the absence of evidence, can the conclusion be drawn that the effect of the law is discriminatory, or that persons are acting in a discriminatory manner by virtue of the law? In my submission, Your Honor, there is no evidence to draw that conclusion.
You're not suggesting that it is not possible to rule a law to be unconstitutional without any evidence?
No, sir, I'm not suggesting that at all. In Zuniga, that is what Your Honors did. Your Honor found that the minimum mandatory sentences were grossly disproportionate. You could tell that from the law. In Orozco and Belize, a man who has anal sex is guilty of an offense. There's a constitutional right to privacy in your own home. Anybody says, I have anal sex in my own home, has to say, well, look, this law, which says that I can't do it, contradicts that fundamental right that I have to privacy in my own home. You don't need a charge in that case. It is clear from the facts which are put forward and from the content of the law that it is unconstitutional. I'm not at all suggesting that a court cannot find the law unconstitutional on the basis that there is no evidence. So I'm only saying that in this case...
It all comes down to improper purpose, because
yes.
I think you're conceding that if the law had said that it was an offense for a man to be dressed in female attire, or for a female to be dressed in male attire in a public place, you would concede that that by itself would have to be struck down.
I think that that would be discriminatory, and the law hinges on the phrase improper purpose. I think that that would be also a breach of the fundamental right to freedom of expression. So improper purpose is what makes it intelligible. You have to do it for something wrong. And unless everyone has the fundamental right to dress in a certain manner for an improper purpose, then it is not unconstitutional. Your Honors, the Society Against Sexual Orientation Discrimination complains that they were struck out by the Chief Justice on the basis of locus standi. They say that there is the power granted by the Constitution for people to act in a representative capacity and groups to act for their members. That is not in contention. There's a difference between what is having locus standi to bring a case and being a proper and necessary party. The SASOD is the short. I hope Your Honors don't mind if I call it SASOD. SASOD has said nothing different from the appellants. SASAD has not put forward any different submissions from the appellants, and it simply adds to the cost. If costs are awarded against the state, SASAD is an additional party to whom costs have to be paid. The court must be aware of superfluous parties. How many parties do you really need? If SASAD wanted to bring the case, SASAD was free to do so. The Constitution allows it.
Yeah, but if they were free to bring a case, then why can't they simply join somebody else's case if they were minded to bring the same case?
If they want to say something different or they have different legal representation, it is a matter of fact for the particular court in the particular matter, of course, what the issues are. But SASAD has said nothing different. The affidavits mirror those of the other parties. The submissions are the same submissions, the lawyers are the same. So they are
So then it doesn't prejudice.
It does, in terms of costs, sir. If costs had been awarded, if the state had lost the case twice.
But how would it increase your costs if they're saying the same thing?
Well, an open-minded court would say, well, these people are not adding anything new, so they're not entitled to cost. But I can't guarantee that that would be the situation. So,
as one gathers, they would be represented by the same counsel.
well, if the court were to order that the state pay the cost of each of the respondents.
No. They couldn't get double costs when they had the same counsel.
Or quintuple costs.
In any event, Your Honors, SASAD is not a party to this appeal. SASAD is not an appellant. There are 4 appellants.
Okay.
So SASAD was an appellant in the Court of Appeal, but asked for no relief in the Court of Appeal. And SASAD has not now appealed, but the other 4 asked for relief in relation to SASAD. I don't know whether that...
So then you don't need to address us about them?
No, sir.
Okay.
Except to say that.
Right. So you will save costs by doing that.
And time.
Your Honors, I rely on the submissions which were put before and on the address by Lord Sumption on social change coming from Parliament. Your Honors have to some extent gone in that direction in Zuniga. And Zuniga was a very serious case. Your Honors have to some extent said that Parliament can make its own laws, even in that situation. And Lord Sumption gives the reason why Parliament should make those laws. Your Honors, Mr. Selwyn Peters has asked if he can address the court for 5 minutes after I'm finished. Unless there's any other question, Your Honors.
Do you know what he wants to address the court on, just as a matter of interest? Do you know?
It is on a decision relied on by Mr. Mendez, RVS, I believe it is a Canadian decision, I think.
He wants to address on what matter? Which case?
On a particular decision relied upon by Mr. Mendez.
RDS?
RVS. Yes, sir.
Just one question. I was wondering about this cross-appeal.
The cross-appeal, sir, is part of the appeal, is an inherent part of the appeal that
I mean, it's very fitting to have a cross-appeal in this case, but...
there has always been a cross-appeal, sir, since...
But you seem to... You say the relief sought is to affirm the decision of the Court of Appeal. Now, if you want that affirmed, then you... So what is the appeal about, the cross-appeal about?
On the issues which are cross-appeal, sir. It may have been a mistake, sir.
Yeah, because if you want us to affirm it, well, you don't need a cross-appeal for that. If you say, I don't agree with that particular point, so do something about it.
It was an appeal against a particular finding of the Court of Appeal on an issue which I believe to be intrinsic in the entire...
Because in the end, you want us to affirm this issue.
Your Honor, may I respectfully ask that the cross-appeal, the relief sought in the cross-appeal, is to reverse the decision on the Court of Appeal on the ground that the matter is academic and hypothetical, and to use the evidence in the magistrate's court would be an abuse of the process of the court and res judicata. That is what...
So, to what kind of conclusion does that lead then? If you say, well, they made a mistake.
Your Honor, I can look at it in a second and address your...
I'm just trying to understand it. I'm sure you didn't file it for an improper purpose. So.
I hope so, sir. I apologize for taking the court's time. I'm just trying to get it up. Your Honor, it says the affirming of the decision of the Court of Appeal on the grounds relied upon by it in its judgment, as well as on the grounds of cross-appeal set out above, which are the grounds of cross-appeal are set out in paragraphs 2A and B.
That's your res judicata point then.
Yes, Your Honor, it is res judicata, abuse of process, entirely academic, and without live issues for resolution. In my submission, Your Honors, the subject of the cross-appeal is inherently mixed up with the subject of the appeal. They go together, but the respondent's submissions go together. So it should not have been separated by the Court of Appeal.
Mm-hmm. So you really didn't need a cross-appeal? You could have made that part of your...
No, sir, because Your Honors would have told me that we can't reverse the decision of the Court of Appeal because there is no cross-appeal.
Right. So you say you would have had to appeal?
I had to file a cross-appeal on that issue. Your Honor, Your Honors, I am advised that Ms. Kite would also like to address the Court briefly. Ms. Kite, Solicitor General. Unless Your Honors have any further questions to me.
No.
Those would be my submissions.
Yes.
I thank you, Your Honors.
Mm-hmm.
Great for Your Honors. Your Honors, respectfully, I believe the difficulty is not in the charge, it's not in the offense, but perhaps how the charge is framed. I say this, Your Honor, because there is another criminal offense in Guyana which comes under our Criminal Law Offences Act, conspiracy to commit a felony. When persons are charged with that offense, the felony which they allegedly conspired to commit is stated clearly, so that you are charged with conspiring with someone to commit a felony to wit. The charge then goes on to say, what is the to wit? What is the felony? I believe respectfully that once the charge here is properly framed, then the defendant will know exactly what he or she has to answer. And once they know that, then to allege that it is unconstitutional then becomes a little difficult. Because if it is that you're being charged with wearing female clothing, the improper purpose should be stated in the charge itself. And once that is done, the defendant right away, immediately, knows what that improper purpose is and what he has to answer and how he has to defend it. So therefore, at that stage, the issue therefore is not the offense itself, but the application of it. How the prosecutors and how the magistrates deal with it. So I've said all of that to say that the issue which should be dealt with for the, not just the transgender community, because it is my respectful view that this offenses across the board, for citizens of Guyana on the whole, is ensuring that the charges are properly framed so that persons know what they are answering to. We do it with the other offenses. We do it with the offense of conspiracy to commit a felony, and it surely can be done with this offense.
So you're suggesting that if law enforcement properly charges by specifying what the alleged improper purpose is,
yes, please,
then there can be no complaint about the law?
I doubt whether there could be a valid complaint about the law then. So that the issue, I believe, respectfully, is not in the law itself, but in its application.
But why isn't it a crime if a female dresses as a female for an improper purpose?
Because the offense on the books right now is when the female dresses as a male to commit an improper purpose. We would have to change the law for that to happen. Parliament would have to change the law.
No, you see, the complaint about the law is that it is breaching the equality provisions of the Constitution. And what Mr. Mendes is saying is that here you have a law that penalizes a man who is dressed as a woman for an improper purpose. Well, why doesn't the law similarly penalize a woman who is dressed as a woman for an improper purpose?
Well, actually, that...
the same to-wit, the same specification that you say cures the law, that same specification, why isn't a woman who dresses as a female to commit that specified purpose or for that specified purpose also subject to prosecution?
My submission doesn't cure that part of the law. It cures only the improper purpose. That part of the law would have to definitely go back to Parliament because that was never contemplated. And why we have contended that there is no discrimination in gender in respect to this law is because a man and a woman could be charged under this law. This is not a law which just only targets male, respectfully. It targets females also. If females are dressed for an improper purpose.
That argument reminds me of the argument that was made in a Belize case, Wade and Roche's, that said, I think the law said that, well, if you're a teacher and you have a child while you are teaching, then you have to be, whether you're male or female, you have to be dismissed. And they said, well, this is not gender discriminatory because it's whether you're male or you're a female. If you have a child while you're a teacher, you can't continue teaching because this is a good, nice Christian Catholic school, and we don't want teachers who are having children out of wedlock. But the Chief Justice said the law was discriminatory because its impact on women was far more forceful than on men. And in the same way in this case, its impact on a particular grouping is far more forceful. So why doesn't the same analysis apply?
Yeah, but respectfully, Your Honor, the fact remains that as the law is, how it is on the book, how it is stipulated right now, if a female adorns herself in male garments for an improper purpose, she can be charged too. And it is just that perhaps in recent times, we can't point to any such charge. But the fact of the matter is that it is still in the books, and that is why it applies across board. What you find, what has happened, I believe, is that more males have been charged on this section because for some reason or the other, you have more males perhaps dressing as female and as females, and perhaps the police or the prosecutor, depending on the circumstances. And that takes me back to the affidavit of the police prosecutor in this matter, Your Honors. He was able, I don't want to rehash, and I fully agree with Mr. Ramkaran that perhaps we should not become to engage in the facts in the magistrate's court because all those facts are not before this court. Because you see, if we had those facts, and again, if the appellants had brought all those facts to this court, in the magistrate's court, and I'm speaking totally from experience, having been a magistrate myself, things don't happen in a vacuum. When the charge is read and a plea is taken, if that plea is a guilty plea, the prosecutor then states what those facts are. The magistrate, if on those facts a criminal offense is not made out, the magistrate has that onus, has that duty to still discharge the person. Even if after you plead guilty, the magistrate can go on and enter a not guilty plea for you based on the facts, so that the magistrate, who is presumed to have acted regularly and in compliance with her duties as a judicial officer, would have seen, or she should have had facts before her which constitute that improper purpose. In conjunction with all of that, given her the presumption of regularity, in these circumstances, Your Honors, you have the fact that the police prosecutor gave an affidavit in which he swore to what the improper purpose was in these circumstances. So respectfully giving a lot of credit to our court and our judicial system in Guyana, I do not believe persons will be convicted in vacuum, whether or not they pleaded guilty or whether or not facts were laid. The improper purpose would have been on that record. We don't have that record here.
Okay, thank you.
You just said that the law should go back to Parliament.
Yes, yes, please.
Why should a law go back to Parliament?
Please
Why should a law, or this law, go back to Parliament?
No.
Only if there's something wrong
Yes,
with the law?
only if there's something wrong with it. I was
That
talking,
is what
I know.
the other side is saying.
You know, I don't think the law as is, there's anything wrong with it. I was addressing the Honorable President in relation to whether a female, I believe, is dressed as a female. And I'm saying that in that regard, that would be a totally new offense. You see, this offense speaks to cross-dressing. So, you know, for the improper purpose. The female dressing as a female for the improper purpose, that's a new offense. I'm not saying that anything is wrong with it. It just would be a new offense. So that is why I said that that would have to be a function of Parliament.
Okay.
Grateful.
Good afternoon, Your Honors.
Yes,
my comment will be probably less than a minute. I just wanted to point the court to one decision. It's a decision from Canada, and simply because of the comments of Justice Witt and Justice Barrow, and that's the case of RVRDS, and the citation is 1997, 1 SCR 484.
Is this part of the record?
No, actually, it's not part of the record. I'm happy to have it passed up to the court, but I think because of the comments made by the justices, I simply wanted to point the court to a particular paragraph that I think is very important, and the court may consider it in its deliberation.
That's a Nova Scotia case with Connie Sparks.
That's correct, Your Honor. That's very correct, and that was in respect to comments that Justice Sparks made while a black judge and a black accused was in the face of a white police officer. So in Canada, it was unusual because the court was very black that day, which is quite unusual.
I am very familiar with the case. The only two black people in the court was Justice Sparks and the defendant.
Right. And the officer was white. Anyway, I think what I would like the court to do is pay attention to paragraphs 116 to 120 of that.
Would you just slide it over so we see more English and less French?
Excuse me?
Slide it over on the screen.
Oh, sorry.
Thanks. Yes.
I actually like the French part. But
Well, that's the reverse of that case.
Excuse me?
I'm saying to my brother, it's the reverse of the Canadian case.
Yes.
In terms of the ethnicity.
Yes. But I think paragraph 120 is important.
120?
Yes. And this is what paragraph 120 says. It says, regardless of the background, gender, ethnic origin, or race, all judges owe a fundamental duty to the community to render impartial decisions and to appear impartial. It follows that judges must strive to ensure that no words or actions during the course of the trial or in delivering judgment might leave a reasonable, informed person with the impression that the issue was predetermined or the question was decided on the basis of stereotypical assumptions or generalizations. So I think I wanted to point out RDS because it seems
You're
like...
arguing on behalf of the state?
Yes, I am. I am. And the state position is judges are presumed to be neutral. I mean, the state can't take a position that judges can stereotype or can render judgments that are generalized and discriminate against a particular group. The state can't take that position regardless of what tests we employ. And so what I'm saying is if the court is considering any comments made by Justice Robertson, or if the court is considering the comments made by, or the kicking out of the transgendered persons that one of the justices referred to a few minutes ago, that doesn't go to a constitutional realm in these two particular cases. What it does is it may show some insensitivity on the parts of the judges, and I think this court, it's important for this court to, whether it's this law or any other law, to say that judges cannot stereotype.
No, but the problem is that the appellants are saying is that this law, it lends itself to judges using stereotypical thinking in order to convict transgender people. And that in the experience of these appellants,
yes,
you had a magistrate who did precisely that, who was charged with the responsibility of finding out whether the facts revealed an improper purpose and made out an offense, who was charged with the responsibility of determining what was a fit sentence, and who betrayed a bias such that one must now question whether that magistrate was impartial in determining whether the facts that were presented to her made out an offense, and in apportioning, in handing down the sentence that she handed down. RDS was a different case. I'm very familiar with RDS. Yeah. This was a case where Justice Sparks made a secular comment that suggested that white policemen often overreact when they are confronted with black adolescent youth, black adolescents. And the Supreme Court said, well, judges are entitled to, and this is why you have diversity on the bench, they are entitled to take their life experience into account, and that the comment did not reflect any bias. Yeah. This is a different situation. These comments are in a totally different character, of a different character.
I appreciate that, Your Honor, and congratulations on your ascension to Chief Justice. I appreciate what you just said, and this paragraph simply reinforces what you just said. Thank you very much.
Thank you. Mr. Mendes, you won't be long, will you?
The leading question.
3 quick points.
Counsel, do you know I would have phrased it differently? Which was, Mr. Mendes, do we need to hear you? But, matter for you.
Yeah, very quickly. It is, respect to my learned friend, a vague law cannot be cured by providing particulars of the offense. You assess whether a vague law is vague before the charge is made. The whole idea of the vagueness jurisprudence is that the law must be such as to provide advance notice of the conduct that it prescribes. So you don't have to wait until you are charged and then you are given particulars of what is being alleged against you in order to know exactly how to conduct yourself. The point is that if my learned friend is right, and that a vague law can be corrected by giving particulars of the charge, then no vague law will be held to be unconstitutional, because they could always be corrected in that way. Second point, this is the last point. The authorities of the learned friend Mr. Ramkhan was referring to, where the court grapples with the concept of an improper purpose, are cases either dealing with public law challenges, where you're saying a public official has acted for an improper purpose, or you say that a company director has acted for an improper purpose. In both instances, you are able to determine what an improper purpose is by examining the statute and determining what powers have been vested in that public official. In the context of the Zuniga case, the argument, as I recall it, and I'm embarrassed because I'm speaking about a case in which I was involved very intimately, it was being alleged that the law was passed for an improper purpose because it was targeting particular individuals, and it was being used in the public law sense that the legislature was exceeding its constitutional powers.
It was an ad hominem point which was being litigated, and that was the improper purpose.
And that is what was being alleged was an improper purpose. But of course, that is being used in a public law sense, that you are acting outside of your powers in the statute, and the court must then look at the entire statute and interpret it to determine what your powers are. The same exercise is involved in determining whether directors have acted for an improper purpose. So you look at the memorandum articles of association of the company to determine exactly what their powers are, and of course, all of the other powers of a director and duties of a director that would be established under the Companies Act. So you have guidelines and you have legal propositions that you can then test in order to determine whether you have acted for an improper purpose. Of course, there is no such thing in this case. Thank you very much, Your Honor. Sorry.
Yeah, the breach of the peace, that kind of offense, you find that more regularly everywhere, which is also very vague.
Yes.
How would that compare to this vague?
Well, the difference is that the breach of the peace is an ancient offense.
Right.
It would have existed in the common law, and if you want to know what a breach of the peace is, you would find it in the textbooks coming back years where we know what it is. So it is not a modern offense that is created for the breach of the peace where you now have to try.
As I recall, it was the king's peace that you were accused of breaching.
Exactly.
So the king knew what he owned, which is tranquility, harmony, and peace in the realm, and you are not permitted to conduct yourself in any riotous or disorderly fashion which would upset the harmony and the tranquility of the realm.
That sounds like a quote, Your Honor. And I commend your memory.
Actually, it's not, but...
But the point I'm making, Your Honor, is of course that offense would have been developed at a point in time you did not have a written constitution to test it as you went along. So we're now dealing with an offense that is fairly well defined in the common law, and therefore the question of whether it is unconstitutional or not is unlikely to arise. Much obliged.
Okay, thank you, Counsel. We will take time to consider this matter, and we will let you know when we are ready to give our decision.
All rise.